7, this list. Due to some personal difficulty, Lordship, I will not be able to.
Item number
6 and 7.
6 and 7.
Lordship.
Other side, there's a criminal appeal.
Lordship.
It's 2011.
Lordship. Actually, it was.
Are you on bail?
Yes, actually, it was preferred by a private appellant. But thereafter, their counsel stopped appearing in the matter. And then the matter was given to the legal aid, Lordship.
When do you want it?
Lordship, next week.
You are Mr. M.K. Das.
M.K. Das, Lordship.
With the legal aid counsel.
Lordship.
Why, as a legal aid counsel, you want time?
Lordship, I need some time to prepare a little bit more on the matter. Because there are as number as 28 witnesses, prosecution witnesses.
All right, I'm accommodating you today, but you prepare yourself. It's a whole matter,
Lordship.
and it doesn't look good on your part
Lordship.
to adjourn such criminal appeals when you have been appointed as a legal aid counsel.
Lordship.
As prayed for by Mr. M.K. Das, learned legal aid counsel, list, which is not opposed by the other side, relist on, give a date next week.
Lordship. Deeply. First.
May it please, my lord. Because item number 2, my lord, criminal petition, my lord. There's another parthered matter, item number 6, quote number 5. Can it come up day after tomorrow, my lord, or next week?
Item number 2, as prayed for by Mr. P. Mohanto, learned counsel for the petitioner, relist on.
Please, deeply obliged, my lord. Very grateful.
Yeah, please, your lordship. I beg to mention item number 13. Is it kindly matter we pass over for the day only?
13 is a revision petition.
Yes, lordship.
You are for,
Appeal.
as prayed for by Miss MS.
K-tie.
Huh?
K-tie.
K. Tying, learned counsel for the petitioner, relist, which is not opposed by the other side, relist. Yes, give a date.
22nd.
Thank you, sir.
May it please, your lordship. Lordship, I beg to mention item number 16, lordship.
Yes.
Pass over the matter for the day, lordship. Revision petition, lordship.
As prayed for by Mr.
P. Boardley, lordship.
P. Borderlui, learned counsel for the petitioner with, you have to,
Lordship, other side is.
which is not opposed by the other side, relist on, April after the Hudita, on such and such dates. Next,
May it please, your lordship.
Lordship, there is an interim order, lordship.
interim, if any, shall continue till the next date of listing. All right, make it before Bihu.
10th. Oblige, your
May
lordship.
it please, your lordship. I beg to mention item number 18,
18?
18.
Yes.
Lordship, kindly be adjourned for the day. Because CBI.
Have you informed the other side?
Yes, I have the consent, and the CBI council has changed recently.
Mr. Haloi,
Hello, yes.
he's not there.
He's not there anymore.
They have appointed someone.
Not, I think so. They have appointed, but we have taken consent from CBI.
No, because on the other occasions, adjournments were sought on behalf of Mr. Haloi because of his recent engagement in the
Yes.
Directorate of Prosecution. So that's why I asked if someone has been, otherwise on that basis also this matter could have been adjourned. Anyway, as prayed for by Mr.
MS Hussain.
M.
MS Hussain.
MS Hussain, learned counsel for the appellant. With, which is not opposed by the, you have taken consent, you
Yes.
said, no? With consent from the other side, relist,
First week of April, Lordship.
all right.
Thank you. Much obliged.
Call the list, please.
For admission, item number 1.
Any juniors of Mr. Bora here?
One who mentioned just now, he was.
That's why he left.
I've been informed that someone else is heading this matter in Lordship.
Someone else has
Yes,
been
sir.
engaged here. His name, I don't think is shown
Yes.
in that case. Yes, one Mr. V.A. Chaudhary. Correct.
B.A. Chaudhary, Lordship, but
No, for the petitioner, it seems with consent of the other side, Mr. V.A. Chaudhary. Learned counsel appearing on behalf of the petitioner sought adjournment.
His name is not reflected in the cause list also.
His name is not reflected in the cause list.
Yes, Vikram, he is one of juniors, Mr. A. M. Bora, V. A. Chaudhary, Vikram.
V.K. Chaudhary is,
A.
V.A. is junior of Mr. Bora.
Yes, sir. Lordship. But this matter has been listed by order, Your Lordship, so it's not mentioned here, Your Lordship.
By order, can I mention courses?
Also
Mentions. Yeah, that's the next. It will be 17. One Mr. P.M. Bora, senior advocate.
His name is not reflected.
I wonder, no, it is A.M. Bora only, sorry. This is mentioned on the 17-3, posting it on 28-11. No, sorry, seeking posting on 25th March. They have brought it and they are not there. All of these. Mr. Gogoi, if you, I'll just keep it for some time. If they come, we'll see. Otherwise, we'll go ahead.
Very well. Obliged.
All update supplementary. Go ahead.
Supplementary list, item number 22.
Admission book, hold on, huh?
My please, Your Lordship.
Yes, what is this petition?
Herein, Your Lordship. Basically, I have challenged the order of cognizance, Your Lordship, page 22. In this case, Your Lordship, LCR is not there.
So put, like to hear you. So put basically, I don't reflection to TCR is required.
Because already, Lordship, the trial court Lordships, 5 CW witnesses are examined. And then the impugned order was passed, Lordship. All the CW are implicated, the petitioners, Lordship.
All the
Petitioners, Lordship, implicated in CR case, Lordship.
the order under challenge is page 22.
22. Page 15, Your Lordship, this is the complaint, it was filed. And thereafter, the complainant was examined under section 200 of
And
the.
you have obtained a stay.
Yes,
Yes, Lordship.
herein the Ellis date of occurrence,
Let us see the complaint.
yes, page 15, Your Lordship.
Case 15, Lordship.
Yes.
Lordship.
Lordship, page 15,
16, Lordship.
Yes, please read.
yes. I am reading from page 16, Your Lordship.
No, you read from 15, the brief facts.
Yes. The brief fact of the complaint case is that the complainant got settlement of land measuring 48 hands length and 24 hands breadth, which is part of the land covered by Dag number 268, party number 122, belonging to Rongia Nodirpam Jonopriyo, Ansolik Bazar. The president and secretary of the managing committee of the said market gave place for possession and settlement card to the complainant after taking money from him. And accordingly, the complainant started to construct Pakka house in the said allotted place. But on the day of incident, the accused person carrying with hazardous weapons such as knife, dagger, pistol conjointly entered illegally into the land allotted to the complainant. And the accused number 1 made a demand of ₹2 lakh. The complainant, one being failure to pay the same, the accused person threatened him to kill with pistol and broke the post of the Pakka house of the complainant by cutting the road. Thereafter looted away
What
the,
is wrong in this?
herein, Your Lordship, it was
IPC. What is wrong in the order of
The-
taking cognizance?
the
Allegations are made in the complaint clearly
allegation is that, your lordship, the cognizance was taken under section 395 of IPC.
No, I
And the
see.
Ellis. And
Yeah, go ahead.
in the complaint, your lordship, the Ellis date of occurrence is given as mentioned as 10/1/2025, but the complaint was lost on 29.
Mr. Counsel, can this court go into all this question at this stage?
I am
Can
the
this?
primary officer, your lordship, hearing
You
the,
have to make out a case of with that even if the materials collected by the prosecution, the averments surrounding the complaint, even if it's taken on the face value, no criminal offense is made out. Now, if we take these on the face value, obviously there is a criminal offense made out on the allegation. Correctness, this court cannot go at this stage.
before that, your lordship, I would like to say, hearing the dispute is regarding the constitution of the managing committee of the
Whatever is
market.
the dispute.
Now,
There are allegations that you have, the accused have entered and have with hazardous weapons such as knife, dagger, pistol, entered illegally into the land, demanded rupees 2 lakhs.
that is the
Further,
serious
it is said-
allegation, your lordship.
Hmm?
That is the serious allegation, but they, and it was occurred on 10/1/2025, but after 6 months of the occurrence of the incident,
You,
without a
you,
proceeding
Mr.
to the
Counsel,
police,
Mr. Counsel,
with,
charge has been framed.
no,
Then
only
you-
cognizance
at-
was taken.
you will get all the opportunities. You have come before this court at the outset and you have obtained stay of an FIR which is pending from 2015.
No, this is not.
The entire, in the complaint, the entire criminal proceeding has been stayed because of this case. We are in 25 now.
Therefore, only I am saying, your lordship, the statement of the witnesses.
No,
may
no.
call for
I
your
am
lordship,
not,
because
I
there
am
is
not
no case
convinced.
at all, your lordship.
I am not
Because
convinced
the
at all.
Ellis incident. was-
Sorry,
Lordship, kindly have a look, your
sorry.
lordship.
If you,
I'm- I-
if you
I'm
wanted, you
trying-
could have annexed those statements. Not at the, it's too late in
No,
the
that-
day.
Kindly, lordship, see. 395, the cognizance was taken under section 395,
Frame, charges
And
has
they-
not been framed till now, Mr. Counsel.
lordship. But on the very,
If there is
Yes, yes.
nothing there, you can pray for discharge. You have a lot of remedies open.
therefore, your lordship, I am praying, your lordship, let call for the LCR, your lordship.
No.
The after,
This is not a case
After
for calling.
finishing the
Why did you
statement
not
of the
make this
witness,
prayer at the
if
time
your
of
lordship-
admission, at the earlier stage? Why now in the year 2025?
lordship, one.
When
submission.
everything has been already stayed, you could have sought for it. If there was an order from this court calling for TCR and TCR has not come, certainly I would have accommodated you. But you have not done that
But
since
on the,
2015,
on the
since the
very
date of
first
filing
thing, your
this
lordship,
case,
the in-
2016.
the interim order was basically passed
Many-
on that ground that the incident was take place on 10/1/2015.
That's all right.
And they,
I'm
without
not
approaching
bound by
the
the
police,
interim order,
after
Mr.
6
Counsel.
months,
I'm
they
not
fi-
bound by the interim orders passed by this court. Interim orders are not final orders. Now I'm taking it up for final disposal.
now,
Reading of the complaint, there appears nothing erroneous. And the order of the magistrate appears is of that the magistrate has applied its mind on the basis of the complaint petition, statement of the complaint, the statements made by the complainant's witness. So this court doesn't find anything.
5 CW lordship, examine lordship.
let me,
Cognizance taken.
lordship, kindly see
Sorry.
the background of this complaint, your lordship. I would like
Background,
to
we
see.
can't go at this stage. Mr.
Herein the
Counsel,
dispute is regarding the
Counsel,
constitution of the
Mr.
managing committee, your
Counsel,
lordship.
you are an
And
officer
for
of
that
the
reason,
court. You are aware of the limitation of this code under 482, correct?
yes,
How can this court get into all these disputed questions at this stage?
therefore only I
Let
am
the,
saying,
let
your
the
lordship,
investigation be
that
completed.
statement
If
of
there
the-
is nothing, you will get a FR. And if
No.
there is something, you will still get a chance to show that and see if
This
you
is
can be
not-
discharged. Sorry,
therefore
your
only,
name, Mr. M. Khan? Heard Mr. A.M. Khan, learned counsel for the petitioner. Stop. Also heard
And Ahmed,
and Ahmed, learned counsel for the respondent number,
complainant lordship,
for the
One.
respondent
1.
number 1 and MS SH Bora, learned APP for the state respondent. Stop.
State is not party here.
No, what is this order? By hand, state of Assam is written here. Yes. How can, you have not made the state a party, but subsequently by hand, I think there is an order of this court 9/2/17. Of course, otherwise on that ground also this petition can be,
Because the complaint case, therefore only I said.
yes. How can you, Mr. Counsel, if you insist that, then I can dismiss it in on one line. How can you say that in this
No,
petition,
no,
the
by
state
hand,
cannot be a
if
party?
something written by me, your lordship, by hand.
No, no, it's not by, Mr. Counsel, the difficulty is that you people don't look into it. There is an order, there's a judicial order of this court. On that basis, corrections have been made. Pertinent that at the time of filing of the criminal petition, despite the petitioner has not arrayed the state as a party respondent. However, this court by order dated 9/2/2017 directed the petitioner to implead the state of Assam as respondent number 2. Accordingly, the cause title was amended and state has been accordingly the cause title of the criminal petition has been amended. Stop. By way of this petition, under section 482 CRPC, read with 401, section 401 CRPC, the petitioner is seeking quashing of the complaint case being CR case number 1806/2015, pending in the court of the learned JMFC Borpeta, hereinafter referred to as the Magistrate Court, and the impugned order dated 26/5/2016 passed by the Magistrate Court in the said complaint case. Stop. The brief facts of the case is that a complaint was filed on, what is the date of the complaint?
26.
Where do I get it?
Sorry, 29/6/2015.
On 29/6/2015, alleging inter alia that the complainant got settlement of land measuring 48 lands, 48,
48 hands, hands.
what is hands? Huh?
48 hands.
One hands in the 18.
Measuring
say.
48 hands length and 24 hands breadth, which is part of the length covered by DAG number 268, Patta number 122, belonging to Rongya Nadir Pamjanpriya Anchalik Bazaar. It is alleged that the President and Secretary of the Managing Committee of the said market, petitioner number 1 and 2, President and Secretary of the Managing Committee, petition number 1 and 2 of the said market, gave place, possession and settlement card to the complainant after taking money from him, and accordingly the complainant started to construct Pakka house in the said allotted place. However, on 10, it is further alleged that on 10/1/2015, the accused persons, petitioners, carrying hazardous weapon, entered into the land allotted to the complainant and demanded a sum of rupees 2 lakhs by threatening to kill him with pistol in the event the payment is not made. So, accordingly, the complaint was filed. Thereafter, the complaint was registered as CR case 1806/15 before the magistrate court. After the investigations were completed and the statements of the complaint along with the complainant's witnesses were recorded, the magistrate court by order dated
26.
by order dated, where is the order in this page 22?
Page 22, 26/5/2016.
I don't see the order date. 20
26/5/2016.
by order dated
Page 22 here.
page. Yes, but in 22, where is the order date? In my copy, there is no date mentioned. (26/5/2016) took cognizance against the accused petitioners under section 395 of IPC. Situated thus, the present criminal petition has been filed by the petitioners accused, wherein this court interim order was passed when?
Twenty 9/16.
I think it was first.
Pertinent that this court by order dated 26/5/2017 was pleased to stay the proceeding of the said complaint case until further orders. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the allegations leveled against the petitioners in the subject complaint case are absolutely false and baseless and has been falsely implicated in connection with the said case. He further submits that the learned magistrate court has totally failed to appreciate the evidence on records and facts of the case and passed the impugned order dated 26/5/16, and therefore the same is liable to be quashed. He further submits that the complaint was filed on 29/6/2015, after a delay of about 6 months from the alleged date of occurrence of the incident I-10/1/2015, and there being no proper explanation regarding the delay of filing the case, comma, the or impugned order taking cognizance on the basis of such belated complaint is erroneous. Stop. He further submits that there is a dispute regarding constitution of the managing committee of the Anchalik market in question, and the dispute leads to constitute two managing committee of the said market, one headed by the petitioner number 1 and another headed by one Imad Ali. And that Imad Ali and 12 others, including the respondent complaint, had filed a writ petition being WPC number 150 of 2016 before this court for direction of restraining the petitioners not to disturb to run the market allotted to the writ petitioner. However, no interim order was passed in the said petition, and therefore the subject complaint has been filed only to harass the petitioners. So, right?
Yes.
These are your
Yes,
submissions.
yes.
For contrast, MS Gora, learned APP, submits that the allegations made out in the complaint clearly makes out a criminal offense, which is yet to be wherein the framing of charge stage has not yet be wherein charge has not yet been framed in view of the stay order obtained by the petitioner in this case. She further submits that the grounds sought, that the grounds argued by the learned counsel for the petitioner supporting the quashing petition can be argued before the magistrate court at the time of framing charge, and therefore such shortcut to scuttle the criminal proceeding at the bud is absolutely unwarranted in law. So, right? Mr. Your name. Your name.
N. Ahmed.
Mr. N. Ahmed, learned counsel for the complainant submits that since the allegations averred in the complaint makes out a prima facie criminal case, the same ought not be quashed by this court. Stop. Heard, perused, considered. Apt to reproduce the complaint which reads as hereunder. A to A, 14, huh? 14. Apparent reading of the aforesaid averments set out in the complaint, comma, it appears that the allegations against the petitioners accused are serious in nature, and if the allegations are proved, a criminal offense is made out. It further appears that based on the said complaint petition as well as the materials collected by the prosecution, the magistrate court, by applying its mind on the materials available, had taken cognizance under section 395 of IPC against the petitioners. It further appears that because of the stay obtained by the petitioners in this criminal petition, the charges, the framing of charge, charges could not, the matter did not proceed thereafter. The matter could not proceed thereafter. Stop. The arguments of the learned counsel for the petitioner as regards delay in lodging the FIR, dispute as regards the dispute as argued, dispute as claimed, not comma, and the dispute as claimed cannot be gone into by this court at this stage. This court, while exercising powers under section 482 CRPC in connection to quashing, in relation to quashing of complaint FIR, has a limited jurisdiction. Stop. The principles enumerated by the apex court in the decision of the state of Punjab versus Bhajanlal, reported in 1991 so and so, wherein the principles really question reads as hereunder, quote unquote 1 to 7, I think, huh? Right, divided. Reportable. Viewed from the aforesaid angle, this court is of the firm opinion that the averment set out in the complaint, if is taken to be correct in its face value, a criminal offense is made out. Therefore, the order of the magistrate, therefore, this court does not find any infirmity. No, I will not say that, because later on you
Yes,
may,
yes.
the charge, I don't want to get into that, because you see, otherwise it will prejudice. Therefore, hence the criminal petition fails and dismissed. I'm not saying anything which might prejudice the proceedings, because we don't know, tomorrow the charge may be may also be changed, or you may get a discharge.
Yes, lovely.
Time being item 1.
Yes, Mr.
Yes, madam. In item 1, my lord, we have not mentioned the, it has been shown as by order, my lord, but we have not mentioned. In case today I am paying for some little accommodation. my
But
lord.
your name is there, mention memo is there, required your mention memo to have you seen?
I have been told, my lord, I have not seen that.
Who has signed it?
I'll just
Mention
I'll just check it
memo
out, my lord.
Whose signature is this? Find out whose signature is this from the office of Mr. Bora. Please have a look. Or is it, I mean, just cross-check, Mr. Mohanta, cross-check the number, criminal petition 208 of 2018.
Yes.
Yes, sir. 208 2000 name is also correct.
Hmm.
Advocate for the party seeking is B. Sharma.
Hmm?
B. Sharma, my lord. Party seeking posting. It's respondent, my lord. Not the
Some-
petitioner, my lord. It's
Appears, huh?
no, not the petitioner, it's respondent, my lord.
Respondent, Mr. Gogoi, you have been,
B. Sharma, your lordship.
who is B. Sharma?
Maybe, my lord.
Anyway,
TP.
huh?
The TP of most.
Anyway, as jointly prayed by both parties, released on
Any
Uh,
date at all.
After Bihu vacation, my lord, immediately after Bihu vacation.
Did you get a date? এখন থৈ দিব ma'am এখন।
Oblige, lordship.
You find out from your colleagues.
Oblige,
Your
lordship.
lordship, I'll oblige.
For hearing, item number 3.
This is Parford. Yes, Mr. Mahajan,
May I please, your lordship? My lord, on
which is this matter?
last occasion, my colleague Mr. D. Bora was there.
That's why I was thinking, because I don't remember you arguing an appeal before me,
Yes, my lord.
which I have heard.
No, what had happened, my lord, last week I was in this post, my lord, and lordship had asked to make a compilation of the evidence, my lord. He has filed a affidavit, my lord, with all the PWs, my lord.
And in the earlier occasion, my lordship, my learned friend, Mr. MP Goswami was appeared. So he was supposed to be appear here. So this is, since it's a part-heard matter, I cannot take up this matter also.
But why was the matter fixed today? Any idea?
My lord,
It's a by
he
sleep
has
found.
missed out, he has not missed out, my lord, my colleague, my lord, there was defense witnesses as well, my lord, and the 313, my lord. That he did not place before your lordship, my lord. I brought that,
DW two.
DW 1 and 2, my lord, and the 313, my lord.
No, but there was one, there was a, okay. Deposition of prosecution witnesses and all are there,
Yes, my lord.
but defense witnesses is not there.
Defense witness, the 313, the FIR was not got on record, my lord. It is there in the record, but not.
So are you going to file something and,
I've brought a compilation, my lord.
okay, give,
I can give the hand on.
yes. We can hear it.
Yes, my lord.
I have forgotten everything, Ms. Bora. If you are ready, we can hear it. Yeah, if the evidences are placed, it will refresh my memory. So Mahajan and Ms. Bora, if you both agree and if you are ready, I can go ahead.
Yes,
All right, you have your, do you want
Nothing.
anything from here?
yes, lordship. Because
Is
I'm
that-
handicapped, no petitions,
Mr.
nothing.
Aditya? Aru. Yes, Mr. Mahajan.
Well, the FIR is at page 1 of that other compilation, my lord.
Just one sec. This is today you have given, right?
Yes, my lord.
Here also, I think this is the FIR.
Yes, my lord. Very short, my lord.
So this I am marking it as compilation number 2. Okay,
My lord.
so that if you have to refer here, you say compilation number 2.
My lord.
So now you want me to go where?
The FIR, my lord.
Compilation 2.
2, my lord.
Yes. Yes.
But the FIR was lodged by PW 5, my lord.
Yes.
He's the uncle of the victim, my lord.
Yes.
Humble submission is that at around 3 p.m. today, the aforementioned accused enticed my niece, so-and-so, 11 years of age, and taking her to Rampur LP school, he committed rape on her inside the school.
Oh, this is that case.
My lord.
I think there are witnesses who have seen her going to the school or coming out from the school.
Only the uncle, my lord.
Nobody else have seen.
And there's discrepancy between the victim and the uncle, my lord. PW 1 and PW 5. my lord.
Okay. All right.
That's the FIR, my lord. The lordship, can you come to the affidavit filed by my colleague, my lord?
Yes.
Therein all the PWs are there, my lord. Page 42 of the petition affidavit.
Compilation.
Page.
It would affidavit from petition from us.
There is a petition. Yes.
42 of what?
You will have the vernacular.
Lordship.
You will have the vernacular. In
Yes,
that
copy was served, my lord.
PCR.
This is one night walk. We do have a process, I think. So that paper is not with us, lordship.
We can have it on
So some other day, lordship.
Thursday.
Yes,
In the meantime, either you or MP Goswami.
yes,
ask
I'll
him or
inform him.
just get hold of those papers.
Yes.
Relist Thursday, huh? The Mr. M. N. Mahajan, the next counsel for the appellant, furnishes the photocopies of translated copies of the FIR and the depositions of the defense witnesses
And the 313, my lord.
and the three statements. The same is kept on record as compilation 2.
Right. Item number 4.
Some instruction was sought from the higher education.
My senior is present. He's in the restroom actually.
He is in restroom.
Okay.
Who is appearing for the higher education? Keep it for some time.
Number 5.
Yes, Mr. Sharma.
Yes, my lord had heard this matter at some length, but the matter has been again fixed for your lordship's fresh perusal.
Written arguments are also submitted.
It's been submitted, your lordship. In fact, your lordship wanted to go through some of the gist of the matter in detail.
Who is appearing for the other side?
I'm responding number 4, you see.
My
And-
senior friend, Mr. Nilanjan Deka, appears for the private respondent. And Siddharth Borua appears for the PCB. Are you there on his behalf? Yes. My friend is there on
And
behalf.
for Mr. Deka?
He was here. He would be here, your lordship. I can assure your lordship that. He was in fact inside the courtroom just a while back.
I think higher education is here.
Yes, lordship,
No, no, like this
Mar-
sign of order.
not ready. Our delegate is right? Lordship, I mean,
All right, after some time, Mr.
okay,
Sharma.
okay.
Are you appearing for higher education?
K Gogoi is appearing, Lordship.
Huh?
K Gogoi is appearing, Lordship.
So I'll take it
timing-
after some time?
After some-
But what is, you see, it appears that some instructions were called. Those have been placed.
Section number.
Dr. Gogoi is not
All right,
not received yet, I think.
let Gogoi come.
Lordship.
Yes.
Item 8, 9 and 10.
I'm for 10, my lord. I'm appearing for item number 9, my lord.
And in 8? Who's appearing in 8? PC Day. He has withdrawn.
13 years ago, my lord, the appeal was preferred.
All right, then we can appoint an amicus for the
Have to be,
appellant.
but to me also, my friend also, he want to withdraw the Okaladhan because actually no contract, I have written letter, they are not
You
responding.
also want to withdraw?
I have not yet decided.
Withdraw?
I know, but
Mr. Councils, even if you're in not contact, that doesn't mean you will
yes,
withdraw.
exactly.
These
exactly.
are criminal appeals. You assist the court. What instruction you need from your client? Except monetary instructions.
No, that is not that. That is
That
not
is
that.
why, except that.
But whether he's alive or not, that is also I do not know.
That, when we can, we'll appoint an amicus in item number 9. In the meantime, you can get the status of the appellants. From, right, that can be done. In
Item number 8, lordship, amicus is required.
8, 9 and 10. একেলগে লব। None appears for the appellant in item number 8. Mr.
PP
Yes, in 9, who's appearing?
PP Borthakur.
Mr. P.P. Borthakur, learned counsel, is present for the appellant in criminal appeal 267 of 2012. And Mr. S.C. Biswas, learned counsel for the appellant in criminal A 268 of 2012 are present. It is present, Mukuba. একেলগে দুজন are present. MS A Begum, MS A Begum, learned APP for the state is also present for the state response. It appears that in criminal appeal 140 of 2012, when the matter was last listed, I 27/6/2023, Mr. PC Day Learned Counsel submitted that he has withdrawn from the case and that he is no longer representing the appellant in that appeal.
PCD, it is.
কোন লেখা?
Order আছে।
ও, এটা উর্দু করেছি। আচ্ছা, উর্দু যেমন নাকি বুঝলাম।
It appears that the office has received the letter from Mr. Anjaman and Mr. PC Day, learned counsels appearing for the appellant in criminal appeal 140/2012, stating their withdrawal, which has kept in the file and marked as W, which is available in the file and marked as W. It appears that these criminal appeals are pending since 2012. Accordingly, in the interest of justice,
They're on bail, all bail.
They are on bail. How do we will dispose of as per merit, Lordship, then if
No,
they
no,
are.
no. There is one case, there is no lawyer.
to appoint
Amicus appointed.
Shri Nimesh
No, no.
Mahajan
Oh,
as amicus curiae to
Yeah.
represent the appellant in criminal appeal 140 of 2012. Let the appeal memo along with all the documents be furnished to Mr. N. Mahajan, learned amicus curiae by the registry. Let these appeals be listed for hearing when?
But,
month of
After Bihu?
after Bihu,
May.
May.
First
But-
week of May.
May I also pray the registry may send a notice to this appellant, my lord, who is the.
In the meantime, MS,
Registry.
Miss, why should registry send a notice? Why don't you write a registered notice and find out and you see the appeal cannot be kept pending because you are not in touch with your client. These are criminal appeals. Criminal appeals can be always heard. There's no.
In two
necessary-
occasions, my lord, I have sent notice in the year 2018 and 2023. It was duly delivered, but no response.
That's okay.
I don't have.
In
no
the
phone
meantime,
number also.
let MS A Begum, let APP seek status of the appellants through the jurisdictional police station. To find
Yes.
out.
12.
Lordship will find out, but we don't have any, I will take from.
It is there, you
No,
record
no,
everything.
Copy may be furnished to us, Lordship.
I think you can find out from the jurisdictional police station.
That- Appeal copy will furnished for, let the copy may be furnished.
MSA Begum submits that the copies of the appeals are
Like-
not available.
Not available.
Are also not, no, that I think, Mr. Biswas,
In my appeal, I can give.
I
The
can-
other two appeals, may who-
For 9, I can put.
for 10 I can give. One from registry have to give it.
Mr. S.C. Biswas and Mr. P.P. Borthakur assures that the appeals,
of
that
the
copies of the appeal memo and the relevant documents shall be furnished to MSA Begum and APP. As far as criminal appeal
Acha, Murel.
140 of 2012 is concerned, let registry furnish the appeal memo along with the relevant papers to MSA Begum as well, let APP as well.
May.
Item number 11.
And let registry reflect the name of the amicus curiae in the cause list.
I think they will ask you.
Yes,
My lord, I am for the respondents, my lord, petitioner counsel is absent.
last occasion also absent.
Yes. I have come to know from the reliable source that this petitioner has expired. I do not know, my lord, I do not have any record.
Petitioner is in jail. Appellant is in jail.
I do not know, my lord. Perhaps, as per my information, he is expert.
Oh, expired.
He is expert, as
No,
per
but
my
what
information.
document is there?
That,
We have to bring the instruction.
None appears for the appellant on call. Heard Mr. B. Chetri, Learned Counsel for the respondent, as well as Ms. A. Begum, Learned APP for the state respondent. It is submitted by Mr. By Mr. Chetri that he has been informed that the appellant in the meantime has expired. Stop. Let Ms. A. Begum, Learned APP obtain instruction in this regard from the jurisdictional police station and furnish the same before this court on the next date of listing.
A copy of the order may be.
Let a relist on such and such date. Let a copy of this order of today's order be furnished by the registry to MS A. Begum, Learned APP for doing the needful. Eto agote to koi diba de, agote in take date.
Item 12, my lord, only the petitioner counsel is available, my lord. His presence is also necessary so that he can also get the information.
It's all right, let her get it. We will see what happens on the
Lord.
next date, Mr. Chetri. We cannot force someone to appear. Then appears for the petitioner on call, relist Friday, take it on after DD, relist on Friday in the order column with the remark for dismissal.
Item 14.
Then appears for the petitioner on call, heard MS A. Begum, Learned APP for the state respondent. It appears that on the last two consecutive occasions, 9/6/2020 and 9/6/2023, also, there was no representation on behalf of the petitioner. That being so, the revision petition stands dismissed for non-prosecution.
15.
15. 15, I was appointed, my lord.
Yes.
I need a week's time, my lord.
Why?
My lord,
You were appointed long back,
my lord,
22 also.
But
You
the-
sought 2 weeks time, for a week's time only.
yes, yes.
22 also you
But-
sought week's time.
Then it didn't come, my lord. I studied it again, I forgot the brief.
But, how can you forget if you study once, Mr. Counsel?
My lord,
Huh?
I've been handling all these civil matters out of studying this criminal case comes in. My lord, then fix on Thursday if possible.
Oh, next week, one.
Next week.
You are for the respondent.
1, 2, and 3. In fact, my senior was engaged by Mr. N. Borua. His name reflects the cause list, Mr. Navonit Borua. But I'm appearing for the respondents because my friend had just intimated me that he's not ready to do the matter. Any date next week, your lordship.
I won't be taking, I can give that another thing. I won't be taking under more time, my lord.
No, you
Last time.
see, if you take time, we'll have to replace you, then you are an amicus.
My lords.
Amicus does not have the luxury to seek time,
But it's that.
and that too in
area is
criminal
totally-
appeals pending since 2012.
My lords. Area
Where
is
do you
totally
have this
different.
luxury, Mr. Counsel?
Well, any date, not today, my lords.
Uh,
Maybe
We
tomorrow
are
also, or day after
accommodating
tomorrow also.
you today, but be mindful, it doesn't look
Hmm.
good
My lords, I know,
for
my lords.
seeking adjournment in criminal appeals.
My lords.
We can always go through the evidences together. It's the assistance that is required from the councils.
My lords.
If
I
it
understand, my
doesn't
lords.
come,
Just
it
today,
is
my lords.
difficult.
Normally, I don't see it.
As prayed by Mr. D. Gogoi, Leonard Amicus Curie, which is not opposed by the other side, relist on next Tuesday, Didia.
Next Tuesday. Publish, my lord.
Item 17.
Yes, Mr. Nawaz. What is this?
This is a revision petition, madam, against concurrent findings of guilt, madam. I was convicted under section 138 of the NI Act, madam. And subsequently, I was sentenced to pay a fine of rupees 3,80,000. No, actually, Your Honor, Your Lordship, my senior is in court number 17, division bench matter is going on, death sentence matter.
Who's your senior?
Manjit Das, court number 8, Manjit Das.
All right, let us see. In the meantime, your senior can join. You are here.
Yep.
You make notes.
Yep.
You make notes of the argument. Yes, Mr. Nawaz.
Well, I was sentenced under 130 of the NI Act, my lord, and then I was sentenced to pay a fine of rupees 3,80,000. There was a default sentence of 5 months simple imprisonment, but otherwise there was no substantive imprisonment term. So I preferred an appeal, my lord. That appeal was registered as criminal appeal 14 of 2016
Appeal against the cognizance.
against the conviction order. My lord. Conviction order, my lord, and the appeal was dismissed, my lord. Now, your lordship, in this case, the facts, because being the court of third instance, my lord, my scope is also very limited. There are certain facts which are not in dispute, my lord. So I'll not go into that, but for your lordship's clarity, I'm just pointing it out. The check was, my lord, for 3,20,000 rupees. The date of the check is, your lordship, 12/9/2012. It was first dishonored on 17/9/2012. Thereafter, he again deposited that
17/9?
2012, my lord. The date of this, it was again deposited, my lord. This was deposited again on 10/12/2012. So it is still within that 3 months window, my lord. This time-
Deposited on 10?
10/12/2012, my lord.
Yes.
Then the second dishonor was on 24/12/2012.
24?
12/2012.
Yes.
And then the demand notice was sent on 9/1/2013.
9/1?
2013.
13.
This is within that 1 month period, my lord.
Yes.
And the date of deemed service, because there was no service report, it was deemed to be served on 7/2/2013. And the complaint was filed on 18/3/2013. So everything is within time. As far as the technical issues are concerned, my lord, the complainant has complied with that. So there are no issues with the technical aspects for the NI case, my lord. So your lordship already knows the law on interference by a high court in revision in case of concurrent
Let's
findings.
first understand the facts.
My lord.
We'll apply the
Yes,
law
my lord.
later.
Okay. So my lord, in this case, my lord, I am taking just 2 pleas, my lord. 2 pleas. First plea is, my lord, whether the check amount, that is the actual liability amount. Because only if the check is backed by the
Thus, you have become free from court date?
So that matter is going on I'm for the prosecution side, informant family. Lord, I have some time, my lord. Perhaps I can complete this hearing, my lord. I have some time, my lord. Perhaps I can complete here, my lord.
Complete here.
Yes, my lord.
Because I'll also not take a lot of time. My lord. 2 issues, my lord. First is whether the check amount is backed by a legally enforceable debt or liability, my lord. Because dishonor of a check per se is not an offense unless the check is backed by legally enforceable debt or liability. And the second issue is, my lord, whether the complainant, the respondent, had the financial competence to lend that particular amount of money, my lord. So I'll only be submitting on these 2 aspects, my lord. Now, your lordship will kindly take up the petition, my lord.
Let's go to the first order.
Order, my lord.
That will clarify.
Oh, my lord, my lord, yes. The judgment, the first judgment, my lord, will find at page 36, my lord.
Yes.
Page 36, my lord. Well, the facts of the case, my lord. May I read, my lord?
Yes, please.
The prosecution's case in nutshell is that the complainant, so-and-so, was in a good relationship with the accused being the petitioner, my lord. The accused has sought financial help from the complainant by way of loan, and the latter, in good faith, had lent him a loan of 3,20,000. Your lordship will note this amount, 3,20,000. The accused had promised the complainant to repay the loan after 2 months. After 2 months, when the complainant had asked for money, the accused had issued a check bearing number 009825 dated 12/9/2012 of Assam Gramin Vikas Bank Tezpur branch for 3,20,000 in favor of the complainant in discharge of the debt of rupees 3,20,000. But when the complainant had presented the check for encashment in his account with his banker, Assam Gramin Vikas Bank Tezpur branch, The check was dishonored due to insufficiency of funds in the name of the accused. And the same was returned along with return memo dated 17/9/2012. So this is the first dishonor matter. After he got his information from the bank, he had informed the accused to make the payment. The accused had requested him not to send advocate notice and requested him to present the check in the month of December, when he will have sufficient balance in his account. Accordingly, the check was again presented for payment on 10/12/2012, but it was again dishonored. So this is the second dishonor, 10/12/2012. And the Assam Gramin Vikas Bank Tezpur had returned the check with memo showing insufficiency of fund as the reason for dishonor. On being informed about this fact by the banker, the complainant had sent a legal notice through his advocate to the accused on 9/1/2013 through registered post with AD, demanding the accused to make a payment of the check amount of rupees 3,20,000 together with a further sum of rupees 500 as expenses for notice issued. But the accused had failed to do so in spite of receipt of the notice. This is the case of the respondent in nutshell. The complainant filed the complaint petition on 6/1/2014. Cognizance of offence under section 138 of the NI Act had been taken and summons were issued to the accused, who was allowed to go on bail on his appearance before the court. Particulars of offence under 138 of the NI Act have been explained to the accused, to which he pleaded not guilty and claimed to be tried. The prosecution has examined 3 witnesses, including the complainant himself, and exhibited documents. PW1, my lord, is the complainant, Shashanko Kumar Das. PW2 is Avinash Brahma, the chief manager of the Assam Gramin Vikas Bank, Tezpur branch. PW3 is Manoj Nath, inspector of the post office. He had come to prove the service matter. Accused was examined under
2 is for service.
2 is for, my lord, regarding the dishonor of the check matter. And 3 is for service of notice matter. Accused was examined under 313 CRPC, wherein he stated that he committed no offence. The defense has examined 1 witness, heard arguments. The witness examined by defense is DW1 Ranjit Kumar Das, senior branch manager, Bank of Baroda. So I'll come to the reason why this witness was examined, madam. Now the first point, which was
All right, para 7.
Para 7, madam. Para 7, madam. This is CW1 Shashanko Kumar Das, in his examination in chief, has stated that he was in a good relationship with the accused, Konok Botolo, who is a subject teacher in Misamari Higher Secondary School. The accused had sought financial help from him by way of loan in order to meet his financial needs. He stated that he, in good faith, had lent the accused a sum of rupees 3,20,000. He stated that the accused had promised him to repay the loan after 2 months. After 2 months, when he had asked for his money, the accused had issued a check bearing number so-and-so dated 12/9/2012 of Assam Gramin Vikas Bank Tezpur branch for rupees 3,20,000 in favor of the complainant in discharge of his personal debt of rupees 3,20,000. But when he had presented the check for encashment in his account with his banker, Assam Gramin Vikas Bank Tezpur branch, the check was dishonored by his banker, Assam Gramin Vikas Bank Tezpur, along with a return memo dated 17/9/2012, showing insufficiency of funds in the account of the accused as the reason of return memo. He stated that Exhibit 1 is exhibited the check memo as Exhibit 1, bearing check number so-and-so, issued by the accused. 1/1 is the signature of the accused, which he knows. Exhibit 2 is the return memo issued by the manager, Assam Gramin Vikas Bank Tezpur, on 7/9/2012, showing reason of return of the check as insufficient fund. He has also stated that after he got his information from the bank, he had informed the accused that his check was dishonored, and he should make necessary steps to make his payment. The accused had requested him not to send advocate notice and requested him to present the check in the month of December, when he will have sufficient balance in his account. Accordingly, he had again presented the check for payment on 10/12/2012 in his bank, but it was again dishonored for the reason of insufficient fund, as mentioned in column 19 of the return memo dated 24/12/2012 by the manager of Assam Gramin Vikas Bank Tezpur. The manager had returned the check with the return memo. He stated that Exhibit 3 is the deposit slip of Assam Gramin Vikas Bank Tezpur dated 10/12/2012 along with counterfoil. Exhibit 4 is the return memo issued by the manager, Assam Gramin Vikas Bank Tezpur on 24/12/2012, showing a reason of return of the check as insufficient fund. He stated that thereafter he had issued a legal notice to his advocate so-and-so to the accused on 9/1/2013 through registered post with AD, demanding the accused to make the payment of the check amount of 3,20,000 together with a further sum of rupees 500 as expenses for notice issue. He stated that Exhibit 5 is the advocate's notice issued in the name of the accused person on 9/1/2013. Exhibits 5.1 and 5.2 are the signature of the advocate, so and so, which he knows. Exhibit 6 is the postal receipt. He also stated that his advocate neither received back any AD card nor he received any undelivered letter. Hence, his advocate had written to the Superintendent of Post Teipur on 7/2/2013, and the Superintendent of Post had intimated his advocate why this letter dated 7/2/2013, which was received by his advocate on 9/2/2013. As per the intimation, the letter was delivered to the accused on 7/2/2012, but the accused had failed to do so in spite of receipt of the notice. He stated that Exhibit 7 is the petition written to the Superintendent of Post Tejpur 7/2/2013. Exhibit 3 is the reply letter of the Superintendent of Post Tejpur sent on 7/2/2013, intimating the status of the registered letter. In his cross-examination, he has stated that he knew the accused since 2008. He has stated that it is not mentioned in his complaint petition statement and in his examination in chief the date on which the transaction with the accused had taken place. There was no written agreement. He said that he does not know who had filled up Exhibit 1 check and it was not filled up in front of him. He has stated that he has only checked the signature on the check. He stated that the name of his only son is Kaushik Kashyap, who presently works in a private organization, and prior to his service, he was unemployed. He also stated, Lordship will might mark this one, he also stated that he had only one transaction with the accused, and the case is the result of that transaction. He also stated that his son resides with him. He denied the suggestion that when the check was given, there were transactions for about 1 to 1.5 years with the accused. He stated that there was a transaction between them in the year 2012. He denied the suggestion that the accused did not borrow from him rupees 3,20,000 and the accused had borrowed from him only rupees 1,60,000. He has also stated that he has not submitted any bank statement showing his ability to lend rupees 3,20,000. He stated that he has no bank statement. He also stated that he has not submitted before the court any document showing that he had lent the money to the accused. He denied the suggestion that the writings on the check were his son's. He also stated that he does not know if his son had withdrawn rupees 1,07,000 from Bank of Baroda through a check. He denied the suggestion that he knew very well that his son had withdrawn rupees 1,07,000 from Bank of Baroda through a check. He has denied the suggestion that the accused had returned rupees 1,07,000 out of rupees 1,60,000, but no settlement took place as he had charged interest. He has stated that when the check was first bounced on 7/9/2012, he had informed the accused over phone, but the date was not mentioned. He also stated that he has not cited his son as a witness in this case. He has stated that the distance between Tezpur and Misamari is about 38 kilometers. He has also stated that there is only one address mentioned in the notice. He stated that when the notice had returned unserved, a letter was written to the Postal Department on 7/2/2013 for confirmation, and in reply, the Postal Department had stated by Exhibit 7 that the notice was delivered on 7/2/2013. He also stated that his advocate will know whether in Exhibit 6, a registered letter with acknowledgement due, whether Exhibit 6 is a registered letter with acknowledgement due. He has also stated that in Exhibit 9, the fact of AD card is not mentioned and the copy of delivery slip is also not enclosed with it. He denied the suggestion that the accused has never received any notice. Later on, he stated that he cannot say whether the notice was served or not. He also denied the suggestion that he had lent to the accused rupees 1,60,000, received one check from the accused as security, and that he had misused the check. He has stated that he has not inquired from his son why he had withdrawn rupees 1,07,000 from Bank of Baroda. He also stated that he is not a money lender. He had lent retirement money to the accused. He denied the suggestion that he is not entitled to any money as notice was not duly served. Now, Your Lordship will.
So one thing that you're trying to find out, I mean, what appears is that the date of the transaction was not mentioned, either in the complaint,
neither in the
nor in the evidence in chief. Even during cross.
Cross also he did not. He was confronted, my lord, but he did not mention that. Another aspect, my lord.
And you have been suggesting that this was of
a previous, because transactions had been going on for 1.5 years. He, on the contrary, he has tried to project that this was a sole transaction, because he very categorically stated that there was only one transaction between us, and this case is the outcome of that transaction. We, on the other hand, have been trying to project that this has been going on for 1.5 years.
Any documentary evidence you have placed in
to
your
show that there was other transactions? No, madam. Regarding this aspect, my lord, because he was cross-examined regarding his son withdrawing rupees 1,07,000. Now he denies that. He says that this amount was not withdrawn. He also again reiterates that that part, there was only one transaction. Now your lordship will kindly come to the evidence of sorry, my lord,
No,
evidence of
because, you
DW1.
see, because your signature is there, the presumption
Presumption
is
will be there.
against you.
Yes, my lord.
Now, that can be only rebuttable by
Either by
by a
addition,
proper account,
my lord.
where you'll have to account as
My lord.
how,
Yes, ma'am.
right?
Yes.
Because signature, you're not
We are
disputing.
not disputing. In fact, well, we are not
You
disputing.
have
any
not
of the facts.
disputed any of those technical
No, my lord.
things.
Yes, my lord.
Perhaps what you're trying to say is that about the transaction.
Understood. Our only contention before your lordship is this, that check being my check, my signature being admitted, my lord, all things happening within the stipulated time, presumption is against me. Now I have to rebut the presumption. Now I have two options. Either I adduce defense evidence, or through cross-examination, I am able to put up a probable plea, because burden is, my lord, of the level burden is of the standard of preponderance.
Preponderance of
So
probability.
I have to probabilize my defense. So, my lord, for that, there's only two contentions which I have, my lord.
Can you do that on the basis of your suggestions?
No, my lord.
Suggestions
Suggestions will not suffice. my lord.
suggestions will not
Not
suffice. You have to give some more material
materials, ma'am.
evidence,
So there are only two
which
things.
might create a doubt.
My lord. Yes, ma'am. Lordship has correctly pointed out. So for one aspect is regarding his son receiving a portion of the, because he says that he had lent me 3,20,000 rupees. Now, if I'm able to show that 1,07,000.
That's what I'm saying, any documentary
Yes, my lord.
evidence is there.
Yes, my lord. My lord will kindly come to page 8, para 20.
Let's not rush.
My lord.
Let's continue and
Continue, my lord.
complete this.
My lord. Para 14, my lord. In light of the evidence of other witnesses and the documentary evidence, it is to be analyzed whether the assertions of CW1 complainant have proved the offense under section 138 of NIA. On a careful examination of the testimony of CW1, I find that he has stood firmly on his evidence. Nothing could be brought in his cross-examination to disbelieve him. In the cross-examination of CW1, it was not suggested that Exhibit 1 check was not issued by the accused. It was suggested to him that the accused had borrowed only rupees 1,60,000 instead of rupees 3,20,000. And the accused had delivered to him a check for security purpose, and the check was misused by him. But CW1 has denied the suggestion. He has also stated that he has not filled up Exhibit 1 check. He denied the suggestion that the written part of the check was written by his son. The accused in his examination under section 313 CRPC has stated that he had given the complainant a blank check as security at a time of borrowing of money of rupees 1,60,000. The accused has also stated that Exhibit 1 check might be issued by him as because he had given a blank check to the complainant as security. Thus, from the above, it is clear that the defense side has not denied that Exhibit 1 check was issued by him and Exhibit 1 is his signature. Sorry, my lord. Was with a signature. However, the defense side has denied the check amount was rupees 3,20,000. The plea taken by the accused is that the check was a blank check and meant for security. However, the evidence of CW2, moreover, the evidence of CW2, Shri Avinash Brahma, the chief manager, Assam Gramin Vikas Bank Tezpur branch, has substantially corroborated the evidence of CW1. He has categorically stated in his testimony that Kanak Chandra Bordoloi, this is the petitioner, was issued with checks number 9801 to 9825. And this fact has been stated by him from the check issue register. Exhibit 10, now Exhibit 9 after correction, is the check issue register. He stated that Exhibit 1 is one of the checks of the checkbook issued in the name of the accused, and Exhibit 1 is the signature of the account holder, Kanak Bordoloi. So he also proves, my lord, that these checks were indeed mine, that is on a check.
Kanak Chandra Bordoloi is you.
I'm Kanak Chandra Bordoloi. So he proves that this is my check, my lord. This was never in dispute, my lord. Thus, once it is proved that Exhibit 1 check was drawn by the accused with his signature on it, as Exhibit 1 was.
CW1 is your witness.
No, my lord. Complainant witness.
Complainant.
Complainant witness. Thus, once it is proved that Exhibit 1 check was drawn by the accused with his signature on it as Exhibit 1, the factual basis for giving rise to the presumptions under 118 and 139 of the NIA can be said to be present. Hence, the presumption of section 118 and 139 of NIS mandates the court to presume that the check was for consideration and it was issued by the accused in favor of the complainant for discharge of any debt or liability. Hence, the burden is on the defense side to rebut the presumption under 139 of the NIS. This is the proposition of law, madam. The defense side has tried to rebut the presumption on two grounds. One ground is that the accused
Para
had borrowed.
20 is exactly what I said.
Yes, madam. Exactly.
Read. I finished, but you read.
The defense side has tried to rebut the presumption of two grounds. One ground is that the accused had borrowed rupees 1,60,000 from the complainant and had given a blank check to the complainant as security measure. However, the plea that the accused had only borrowed rupees 1,60,000 from the complainant has not been supported by any evidence. Nothing has been elicited in the cross-examination of PWs to raise a reasonable doubt regarding this. This plea was raised only by way of suggestion, which was denied by the complainant. So, as your lordship had correctly pointed out, this is an aspect which we have not been able to prove, that the loan amount was only 1,60,000.
Even para 21 is, as I have pointed out.
Yes, madam. This is also, my lord, not a tenable plea, my lord, regarding blank check. The accused in his examination under 313 CRPC has asserted that the check exhibit 1 was given to the complainant as a blank check as security for the amount borrowed. However, this plea was taken only by way of suggestion to the complainant, which he had denied. Mere suggestion does not prove that the check was not issued in discharge of any legally enforceable debt or liability, nor does it enable the accused to rebut the presumption on the basis of preponderance of probability. Again, my lord, we are not disputing this proposition. This is the law, my lord. The other ground on which the defense side has taken is that a part of the borrowed money of rupees 1,60,000, a sum of rupees 1,07,000 has already been paid to the son of the complainant by means of a check drawn on Bank of Baroda by the accused. Hence, there is no debt or liability as claimed by the complainant. In order to substantiate the above ground, the defense side has examined one DW, Ranjit Kumar Das, who is the senior branch manager, Bank of Baroda, Tezpur branch. The said DW has stated in his examination in chief that Konok Bodlo accused had issued a check bearing number 531195 dated 13/3/2012 of rupees 1,07,000 to Shri Kaushik Kashyap through his account number so and so. Kaushik Kashyap, lordship, yes, the complainant has admitted that it's his son. The said money was paid to Kaushik Kashyap through transaction number so and so. Exhibit A is the said check proved in original, and on the back side of the check, two signatures of Kaushik Kashyap are written. In the statement of account as on 31/3/2000.
But the fact remains Kaushik Kashyap is not the complainant.
Complainant, my lord. So, my lord, what we were trying to project, because your lordship, he had.
Anyway,
my lord.
Carry on.
Yes.
I am understanding what you are trying to say, that there is no legally enforceable debt. And this indicates, but there has to be a link. Merely because he's the son of the complainant doesn't mean. I could have understood that if it was a partnership firm and the loan is said to have been given to the partnership firm, and you have shown me an evidence showing that one of the partner has been paid, then also you see that probabilization it comes. But here Kaushik Kashyap and the complainant cannot be said one and one.
They are not one and the same.
One and the same person. And where in the evidence of DW1, it is said that this is in respect of that. It is also not said. And this amount is not that amount also. This is a smaller amount.
I'll try to satisfy your lordship.
Mrs. Nawaz, why this court keeps interacting is to give an idea to the counsels both side as what is going in the mind of the court, so that you can accordingly respond. Only for that purpose. Don't take it otherwise. And it is not that if something is coming out, this is what this court is going to stand to also. You don't know what happens till the judgment is being dictated and signed. It can be changed. It depends on you both now, how to pursue this court. But I am only indicating my prima facie views that is going on in my mind. Only to that extent.
So in fact, this is the same ground which finding which has been given by the learned trial.
Yes.
24. The evidence of DW1 does establish the fact that the accused had given rupees 1,07,000 to Shri Kaushik Kashyap, who happens to be the son of the complainant. I find nothing to doubt the assertion of DW1. However, nowhere in his evidence it is mentioned that 1,07,000 was given to Kaushik Kashyap in part payment of the original debt which the accuser owed to the complainant. Now, in this aspect, madam, I'll just take a pause, madam. DW
You
one
are before a revisional court.
provisional court, madam. So
Further scope is limited.
very limited, madam.
You will have to show the error that is committed
Right.
by the appellate court. This court is not going to appreciate and reappreciate
Reappreciate
the
the
evidence also.
Only thing which I will try to satisfy your lordship was that there was material evidence which because
Which is the material
Material
evidence, this
but-
check?
yes, madam.
How
So-
can this be a material evidence to connect Mr. Nawaz, Mr. Huh?
Well,
Mr.
at
Nawaz?
the very outset, I submitted this. Is very, I have a very limited scope, my lord, before your lordship. But he says that DW1 could not have said that, did not say that this was in part payment of the original debt. My lord. To be very fair, my lord, DW1 is a bank official. He can only prove whether this payment was made or not.
Correct, but then that itself is
Yes,
not
ma'am.
sufficient
Yes, ma'am.
to say that you have discharged your burden, because once the presumption is drawn in law, you have a burden to discharge as well, right? It shifts to you.
My lord,
The onus is on you now.
my lord.
So you have to bring some evidence which is
Yes.
in the form of evidence, and on the basis of the evidence, all right, it is not reasonable, beyond reasonable doubt. The standard is preponderance of probability, but there has to be something.
Hello.
Now here, where is the connection except being the son?
Yes. Well,
Just merely he's the son.
That would
Who
otherwise.
knows, the son could have had a transaction with him also.
Well, so when, for that one, I'll again go back to his cross-examination, complainant, because he was very categorical, even before DW1 came as an evidence witness, even at the time of cross-examination of the complainant, my lord, it was specifically put to him that whether a sum of rupees 1,07,000 was withdrawn by your son or not,
Hmm.
and he denied.
He denied.
And he said that there was only one transaction, and this is the,
He may not know.
my lord.
He may not know.
Now, he does not even make his son a witness to the case. Anyway, that is his prerogative. His
No, you
prerogative.
could
my
have brought his son.
son.
You could have also
Brought his son.
brought
Right.
his son. What prevented you from bringing the son?
My lord. So only thing, my lord, on this aspect.
If
I
you
can
would have brought it
Yes.
and he did not come, then also an inference could have been drawn.
Drawn.
But you didn't.
My lord. So
25,
25, my lord.
20, 24 towards the end. In
But
fact,
in other-
DW1
Yes, my lord.
has himself stated that there is no link between Exhibit 1 check and Exhibit A
Exhibit A
check.
check.
He has said that.
DW1 has said this because DW1 being a bank. witness,
Correct, but that is your witness.
My lord.
and He has said that.
Yes. One thing, my lord, which we could have done, perhaps, which we failed to do, was try to establish this link. my lord.
Link,
That
that
link.
link.
That was an error on our part. Lacuna is there, my lord.
That link is not there.
Not there, my lord. Because he otherwise will not be able to show that link. Something ought to have been done by us.
And you see, you didn't examine yourself as also a witness.
My lord. That could have been.
Your 313 statement has no
No
value.
value. Your lordship is correct. Moreover, the transaction was between the accused and the complainant. There is no reasonable explanation as to why the accused had chosen to pay the amount of rupees 1,07,000
That's the problem.
to the son of the complainant, instead to the complainant, although he had borrowed from the complainant. Yes, ma'am.
Correct.
Yes, my lord.
This is, where is all these
My lord.
explanations?
The son of the complainant was not privy to the transaction between the accused and the complainant. Hence, in the absence of any evidence in this regard, I found that a transaction between the accused and the complainant and between the accused and the son of the complainant are distinct and independent of each other. As both the above grounds are found not reliable and are insufficient to rebut the presumptions under 118 and 139 of the NI Act, which lean in favor of the complainant. The defense side has also not taken up the defense that the accused had not received the statutory notice. So that we are not disputing whether that is not doesn't
Then
come
we
in our
can
court favor.
skip.
In this regard, the evidence of PW3, this is also not required because this is regarding my lord service of notice. That is not in dispute. Paras 29, 30, my lord, these are all regard the delivery of notice. 31 also, my lord. No, the basic finding by the courts are confined to these aspects. my lord. The rest of the aspects, whether the check was presented in time, these are not in dispute.
So 43.
40. Yes, ma'am. 42 is given the finding. This is also true that we have not made any payments. And the assertion that the
43.
42. Yes, 43, my lord. So it finds me guilty under 138 of the NI Act, and I am convicted. Now I prefer an
What
appeal.
is
My
the sentence?
sentence is to pay a fine of rupees 3,80,000. No substantive term of imprisonment, madam. Para 46, madam.
In default 5 months.
Default 5 months is there. Default stipulation.
Yes,
is there.
appellate court judgment.
Appellate court judgment, your lordship would find at page 18.
Page 18.
Page 18, madam.
Yes.
Lordship will kindly come to page 20 because 1, 2, and 3, 4 are the facts, my lord. They are just recapitulated. Grounds, my lord. First ground, my lord, the learned trial court
It's all
failed.
right. These are the grounds that you have taken
We
in
took,
your
my lord,
appeal.
we
You have already argued.
Argue that point, then.
Let's come to
The points, then. Page para 6, page para 6,
23.
page 23.
These again are the
Again, this is the
evidence.
evidence, my lord.
These are all probably the same in his
My lord, will
cross-examination.
come to directly to page 27, para 16.
In the arguments, yes,
Para 16, my lord.
yes, 17, 16, sorry.
16 minutes. Appreciating the materials on record, it is found that the complainant has able to prove the check in question amounting to rupees 3,20,000 issued by the accused appellant. Although a question was put to PW1, Shashanka Kumar Das, that the accused appellant had paid rupees 1,07,000 only out of the check amount to the son of PW1, but the same has been denied by PW1. DW1, Konok Bordoloi, although has proved payment of rupees 1,07,000 only through check exhibit D and the statement of account of the accused appellant in the form of exhibit B, but the same is not sufficient to prove the contention of the accused appellant that he has paid the same to Kaushik Kashyap. This perhaps is a bit problematic. This part is proved, that this payment to Kaushik Kashyap is proved. The son of the PW1 against the check exhibit 1. In view of the above evidence on record, contention of the accused appellant to the effect that he has paid a part of the check amount to the son of the complainant is not believable to this court. PW2, Avinash Brahma, bank official, has proved the signature of the accused appellant on the check, exhibit 1, and has also proved the statement of account of the accused appellant as exhibit 12. From the available evidence on record, as already discussed above in this judgment, I have come to the conclusion the accused appellant had issued the check amounting to rupees 3,20,000 in favor of the complainant Shashanka Kumar Das. On being presented, the same was returned dishonored due to insufficient fund, and in spite of issuance of notice, the accused appellant has failed to pay the same. Learned counsel for the accused appellant has submitted on another aspect that the case was filed on the basis of a certificate. This is, my lord, not regarding notice, my lord. Record reveals that accused appellant had appeared before the trial court on 25/4/2013, and he has not challenged the order of taking cognizance in appropriate forum, and has also not resorted to settle the dispute if, as per him, that he had partially paid the amount, and as such, at this stage, I am of the opinion that the accused appellant is not entitled to get any benefit out of the procedure of service of notice. As per Section 102 of the Indian Evidence Act, burden of proof in a suit or proceeding lies on the person who would fail if no evidence at all were given on the other side. Similarly, as per 103 of the Evidence Act, the burden of proving is to any particular fact lies on that person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie on any particular reason. In the instant case, the complainant has not admitted the receipt of rupees 1,07,000 only from the accused appellant to the son of the complainant, and as such, the burden lies on the accused appellant to prove that he has paid the amount to the son of the complainant, who had received the same on behalf of the complainant. Taking a break.
Let's complete this.
On behalf of the complainant against the check amount, the exhibit 1, to which from the evidence on record, the accused appellant failed to substantiate or prove. Hence, upon consideration of the available oral and documentary evidence on record, and after going through the
What is the manifest error?
here, my lord, in the appellate court judgment, my lord, the appellate court has gone on a different tangent, my lord. Appellate court is saying that I am even unable to prove that this payment was made to the son.
That is all right, but the fact is the link.
So two aspects, my lord.
That is what you have to show now.
I'll
If
try to-
the evidence that you have brought, whether you have been able to probabilize or not. You show me that, because that link is missing. All right, I shall resume in 5 minutes.
My lord.
Call, but you were not there at that
It's a
time.
part-heard matter, my lord.
You want it on another date?
My lord, we have filed a written argument. So if any specific clarification is required, or lordship wants to hear the matter afresh.
just a little bit of refreshing, and on that date, I would like to dictate the judgment.
Let it
That
be on
was
some
the
other day, my lord.
purpose of keeping it today. All right, we can have it. When do you want it? Tell me.
Any day tomorrow.
Milord, if not inconvenient,
Let it be a Thursday or a Tuesday.
yeah, in a first week of April, Milord. any
Not
day.
first of April,
First week of April.
first week of April, maybe on the next, on third of April.
Third,
if
let it be on
it's
third.
convenient.
Third.
3rd April. Item number
Five,
Five.
5049 of 2022. Yes,
as per it, relist on such and such.
And let me record our minutes.
I'm grateful, Lordship.
Mr. Gogoi, you are for the higher education, that matter.
Madam, my lords directed us to obtain some instruction, but
Hmm.
otherwise, Lordship, that cabinet memorandum is not there. There is no cabinet proposal is there, Lordship. So Lordship, posted the matter any other day, Lordship. I will provide a compilation and Lordship will hear the matter.
Tuesday, Thursday.
This case, my lord, hearing is already concluded. Only this instruction was there.
All right, we'll keep it on another date.
Otherwise, my lords has directed us to give a
I have
compilation.
seen,
Com-
that compilation has been submitted or not?
Not submitted. So Lordship may, next day I will submit it.
Okay,
Next day. Lordship.
Mr. K. Gogoi, Learned Standing Council, Higher Education, seeks a week's recommendation,
Lordship.
a week recommendation for furnishing the compilation as sought for by this court
Lordship,
earlier.
Lordship.
Prayer not opposed, relist on 8th April,
Lordship.
so and so,
Oblige, Lordship. Oblige.
for further hearing.
Lordship. Oblige, Lordship.
But Mr. Gogoi and you see, arguments appears to have been already done. So you refresh the mind of the court, and then on the basis of the written arguments and your arguments,
Lordship.
I will try to dispose it on that date itself.
Lordship. Lordship.
That is the understanding.
Lordship.
Okay.
Oblige.
Yes.
Lordship has already seen the evidence. Now, my lord, when can our court of third instance, my lord, interfere, my lord? In that, even a judgment, my lord, Monjuram Kulida versus State of Assam. Lordship will kindly come to para 9.
Yeah.
Para 9, my lord.
Yes.
First 3 lines, I'm skipping this pertains to the case, madam. All 3 courts have given concurrent finding regarding the factum of marriage and its validity. It has been held to be a valid marriage. It is a settled proposition that if the courts below have recorded a finding of fact, the question of reappreciation of evidence by the third court does not arise unless it is found to be totally perverse, as your lordship had pointed out. The higher court does not sit as a regular court of appeal. Its function is to ensure that the law is being properly administered. Such a court cannot embark upon fruitless task of determining the issues by reappreciating the evidence. This court would not ordinarily interfere with the concurrent finding on pure questions of fact and review the evidence again unless there are exceptional circumstances justifying the departure from the normal practice. The position may undoubtedly be different if the inference is one of law from the facts admitted and proved, or where the finding of the fact is materially affected by a violation of any rule of law or procedure. Where the court, next page, madam, where the court below considered the material facts and did not take into consideration any inadmissible evidence, etc., the interference is not required by court on the third instance. So what from this is that, madam, if there is material fact and admissible evidence which has not been taken into consideration, then court of third instance can interfere, madam. If it
The
is not,
inference is not required.
no, madam, that is if,
On third
no,
instance,
no, madam, if the court below considered the material facts and did not take into consideration any inadmissible evidence.
yeah.
So if it did not take into consideration material facts or took into consideration inadmissible evidence, madam, then it can by way of, madam, negative
It's
supposition.
where the court below considered the material
facts.
facts and did not take into consideration any inadmissible evidence. All right, so you are saying that in a given case, if suppose the court below did not consider the material
Material
facts
facts.
and took into account any inadmissible evidence, in that situation also the revisional court
Can
can
interfere.
interfere.
Well-
So for that, you would have to show what
My
is
lord,
that material
that is
fact
fine.
that has not been that has not been considered.
Yes.
Because you see, even if it appears that the material, the fact about the second check to the son
Right.
has been considered by both the courts, and they have taken a view. Just because suppose we don't agree with the view taken, that cannot also be a ground. Now, the sufficiency of that evidence cannot be gone into at this stage.
Yes.
If it would have been a case that the court below has absolutely not considered the check
Yes.
issued to the son, then perhaps you may have had a case, but that has been considered. That has been
That's it,
considered.
my lord.
Anything that has not been considered and any inadmissible evidence has been taken. Which is the inadmissible evidence here?
No, inadmissible evidence part is not there, my lord.
Not there.
Only whether your lordship will consider that aspect.
See, considering and is one aspect and how consider is another aspect, right?
Yes.
Now, how can you say that the trial court has not considered the factum of issuing that check to the son? That factum has
Trial court has
considered and has
considered.
agreed.
But-
See, okay, it may have been given also. It may have been proved by DW1, but where is the link? Where is the link to establish?
Yes,
And
That link
especially
admittedly-
because the PW1 in his cross has denied.
Denied.
So that link is not there.
What I am trying to project, my lord, is that had PW1 not denied, then, my lord, what the finding of the learned trial court would be absolutely correct. Because PW1 could have admitted that my son was paid money, this potential.
He may not know. How
Right.
do we know?
But he then denied. This is specific.
Whatever be it.
My lord.
You see, payment of that money to
Right.
the son
Yes.
takes you nowhere until and unless you establish a link.
Link.
That
So-
link is missing.
Yes.
Just because he's a son doesn't cannot be presumed.
Yes, my lord. Presumption is not going to.
I mean, it is not sufficient for probabilizing that defense that you're trying to take.
Yes.
You have to rebut it with sufficient evidence.
Yes, ma'am.
That rebuttable is not
Yes.
by mere presuming and assuming
Yes, ma'am.
something.
My lord is correct, madam.
Cannot be on presumption.
But when considering that I have also come on a very feeble footing, my lord, so this is.
You are trying your best
Right.
to, yeah, this court is appreciating your arguments, but
But your lordship is absolutely
Sadly,
correct, that link is missing. Had I,
unless you establish that link, this court cannot interfere with the concurrent findings of the two courts.
second point is, my lord, regarding financial competence of the complainant. That has been settled by the Supreme Court also, madam, relying on that if the financial competence is questioned, then the burden is on the complainant to prove his financial competence, my lord. I'm relying on a couple of judgments on this aspect, also somewhat similar to our fact, my lord. ये दुकान देखो बसलिंगप्पा दिया और जॉन की एग्जाम दिखा दिया I will first kindly take John K. Abraham versus Simon C. Abraham, 2014, 2 SCC 236. Lordship will kindly come to para 4. May I read, madam? Para 4, madam. 4 onwards, madam.
Para 4.
Para 4.
Yes.
The learned Chief Judicial Magistrate, after considering the oral and documentary evidence led on behalf of the respondent complainant, held that the respondent complainant was making a prevaricating statement as regards the issuance of the check, that he was not even aware of the date when the amount was said to have been borrowed by the appellant. This is also one of the cases, facts in this case, my lord. And that there was material alteration of the instrument and therefore respondent failed to establish a case under section 130 of the NI Act. Consequently, the learned Chief Judicial Magistrate found the appellant not guilty and acquitted him under section 255(1) CRPC. The respondent preferred an appeal in the High Court of Kerala, Ernakulam, and by the impugned order, the High Court reversed the judgment of the learned Chief Judicial Magistrate, convicted the appellant and imposed the sentence to pay a fine of so and so amount as compensation under 357(1) CRPC. In default, to make payment of the fine amount, the appellant was directed to suffer simple imprisonment for a period of 3 months. We have heard so and so learned counsel for the appellant and so learned counsel for the second respondent. We have also perused the material papers placed before us, including the judgment of the trial court as well as the High Court. Having considered the above, we are of the view that the High Court was in error in having reversed the judgment of the trial court. When we examine the case of the respondent complainant as projected before the learned Chief Judicial Magistrate and the material evidence placed before the trial court, we find that the trial court had noted certain vital defects in the case of the respondent complainant. Such defects noted by the learned Chief Judicial Magistrate were as under. Though the respondent, as PW1, deposed that the accused received the money at his house and also stated that he did not remember the date when the said sum of money, said sum of rupees 1,50,000 was paid to him. Next point, madam. As regards the source of advancing the loan of rupees 1,50,000, the respondent claimed that the same was from and out of the sale consideration of his share in the family property, apart from a sum of rupees 50,000, which he availed by way of loan from the cooperative society of the college where he was employed. Though the respondent stated before the court below that he would be in a position to produce the documents in support of his claim, it was noted that no documents were placed before the court below. In the course of cross-examination, the respondent stated that the check was signed on the date when the payment was made. Nevertheless, he stated that he was not aware of the date when he paid the sum of rupees 50. But we'll skip the next part, para 9, my lord.
1 second. 6.4, let's continue.
Well. According to respondent, the check was in the handwriting of the accused himself, and the very next moment he made a contradictory statement that the check was not in the handwriting of the appellant and that he, complainant, wrote the same. The respondent also stated that the amounts in words were written by him. The trial court has also noted that it was not the case of the respondent that the writing and the
These
check.
are also important facts. You cannot ignore them. 6.5 and 6.4 and 5 and 6.
It was not the case of the respondent that the writing and the second filling of the check of the figures were with the consent of the appellant accused. In light of the above evidence, which was lacking in many very material particulars, apart from the contradictions therein, the trial court held that the appellant was not guilty of the offense alleged against under section 138 of the Negotiable Instruments Act and acquitted him. Keeping the above factors in mind, when we examine the impugned judgment and appeal, we find that the High Court committed a serious illegality in reversing the judgment of the learned Chief Judicial Magistrate. While reversing the judgment of the trial court, what weighed with the learned judge of the High Court was that in the section 313 CRPC questioning, it was not the case of the appellant that a blank signed check was handed over to his son, and that even in the cross-examination, it was not suggested to PW1 that a blank check was issued. The High Court was also persuaded by the fact that the appellant failed to send any reply to the lawyer's notice issued by the respondent. Based on the above conclusions, the High Court held that the presumptions under section 118 and 139 of the Negotiable Instruments Act could be easily drawn, and the appellant failed to rebut the said presumption. On that single factor, the learned judge of the High Court reversed the judgment of the trial judge and convicted the appellant. It has to be stated that in order to draw the presumption under section 118, read along with section 139 of the Negotiable Instruments Act, the burden was heavily upon the complainant to have shown that he had the required funds for having advanced the money to the accused. That the issuance of the check in support of the said payment advance was true, and that the accused was bound to make the payment as had been agreed while issuing the check in favor of the complainant. These aspects, my lord, are missing, and we had specifically questioned the complainant as to his financial ability to advance me the loan of rupees 3,20,000 in his cross-examination. Keeping the said statutory requirements in mind, when we examine the facts as admitted to the respondent complainant, as rightly concluded by the learned trial judge, the respondent was not even aware of the date when a substantial amount of rupees 1,50,000 was advanced to the appellant. That he was not sure as to who wrote the check, that he was not even aware when exactly the transaction took place for which the check came to be issued by the appellant. Apart from the said serious lacuna in the evidence of the complainant, he further admitted as PW1 by stating once in the course of his cross-examination that the check was in the handwriting of the accused, and the very next moment taking a diametrically opposite stance that it is not in the handwriting of the accused and that it was written by the complainant himself, by further reiterating that the amounts in words were written by him. We find that the various defects in the evidence of the respondent, as noted by the trial court, which we have set out in para 6 of the judgment, were simply brushed aside by the High Court without assigning any valid reason. Such a serious lacuna in the evidence of the complainant, which strikes at the root of a complaint under section 138, having been noted by the learned trial judge, which factor was failed to be examined by the High Court while reversing the judgment of the trial court, in our considered opinion, would vitiate the ultimate conclusion reached by it. In effect, the conclusion of the learned judge of the High Court would amount to a perverse one, and therefore the said judgment of the High Court cannot be sustained. Next, my lord, Basalingappa.
Cases are contextual, Mr.
My lord.
Nawaz.
My lord.
They found, you see, there are serious lacunas on the basis of which the apex court says the High Court could not have reversed the findings of the trial court. That
Yes.
is, there could be one or two lacunas that have pointed out matches in your
Right.
case, but that itself is not sufficient because ultimately it appears that the trial court have considered all the material aspects of the matter, appreciated the evidences, and have given a detailed judgment by recording its findings.
Just
I
one
don't
aspect,
find
my
any error there.
Just one
The
aspect.
appellate court also has, you see, the appellate court upholding that conviction, at this court doesn't find any error. There could be some typo errors, there could, that part, but that is not sufficient because ultimately one has to see what is also the order of the trial court, which was under appeal, isn't it?
Yes, my lord.
And it doesn't appear that it is perverse, the finding of the trial court. Now, once it is not the findings are not perverse, then the question is if any law has been ignored to make out a case of error in law, isn't it? Now, that is not your case. You are only on the point that number one, the date is he doesn't remember the date of the transaction. Number two, the evidence of the DW1 clearly establishes the fact that some amount, which you claim to be part payment of the loan amount, has been repaid to the son. This is what your case is.
Third, there's another point, my lord, which is there in this judgment, which was not considered by either of the courts, my lord, is regarding the issue of financial.
That it was the duty of the complainant to give the bank balance and show that he had financial capacity.
Especially when we question his financial competence in terms of the judgment. There's
It
another
does not attract.
Yes, sir. One more judgment, my
These grounds are not attracting me
lord.
for exercising my revisional jurisdiction.
This one last judgment I'll try to satisfy if your lordship. Basalingappa versus Mudisappa, my lord, 2019, 5 SCC 418. Lordship will kindly come to para 25.
Para
25, my lord. Internal page would be 63. Sorry, man, page 19. Internal page is 19 and para 25 onwards. Lordship has prepared one. We have noticed the ratio laid down by this court in the above cases on sections 118A and 139. We now summarize the principles enumerated by this court in the following manner. Once the execution of check is admitted, section 139 of the Act mandates a presumption that the check was for the discharge of any debt or other liability.
Para?
Sir, para 25, my lord, sub-para 25(1).
Sorry. Yes.
Sub-para 1, again read, my lord. We have noticed the ratio laid down by this court in the above cases on sections 118A and 139. We now summarize the principles enumerated by this court in the following manner. Once the execution of check is admitted, section 139 of the Act mandates a presumption that the check was for the discharge of any debt or other liability. That is there, my lord. Next, the presumption under section 139 is a rebuttable presumption, and the onus is on the accused to raise the probable defense. The standard of proof for rebutting the presumption is that of preponderance of probabilities. To rebut the presumption, it is open for the accused to rely on the evidence led by him or the accused can also rely on the material submitted by the complainant in order to raise a probable defense. Inference of preponderance of probabilities can be drawn not only from the materials brought on record by the parties, but also by reference to the circumstances upon which they rely. That it is not necessary for the accused to come in the witness box in support of his defense. Section 139 imposes an evidentiary burden and not a persuasive burden. It is not necessary for the accused to come to the witness box to support his defense. Applying the prepositions of law as noted above, the facts of the present case, it is clear that the signature on the check having been admitted, a presumption shall be raised under 139 that the check was issued in discharge of a debt or liability. The question to be looked is whether any probable defense was raised by the accused. In cross-examination of PW1, when the specific question was put, that the check was issued in relation to a loan of 25,000 taken by the accused, PW1 said that he does not remember. PW1 in his evidence admitted that he retired in 1997, on which date he received monetary benefit of rupees 8 lakhs, which was encashed by the complainant. It was also brought in the evidence in the year 2010, the complainant entered into a sale agreement for which he paid an amount of rupees 4,50,000 to so and so towards sale consideration. Payment of 4,50,000 being admitted in the year 2010, and further payment of rupees 50,000, with regard to which complaint number 119 of 2012 was filed with the complainant, copy of which complaint was also filed as Exhibit D2. There was burden on the complainant to prove his financial capacity. In the year 2010-11, as per his own case of the complainant, he made financial payment of rupees 18 lakhs. During his cross-examination, when financial capacity to pay rupees 6 lakhs to the accused was questioned, there was no satisfactory reply given by the complainant. The evidence on record thus is a probable defense on behalf of the accused, which shifted the burden on the complainant to prove his financial capacity and other facts.
Mr. Nawaz, whether I understand that if you had brought something, some materials, documentary evidence or something to indicate that he was financially sound, he had the capability. Of course, this court would have said that you have discharged that burden as regards probabilizing your defense. But you have not done all this. What you have done is you have simply put a suggestion, which he denied.
This doctor will kindly just take para 30 for once. Then I'll go to the evidence on this part. Para 30.
Yes. Here, in this case, there are materials to show of sale transactions.
On this, may I read para 30, madam? We are of the view that when evidence was led before the court to indicate that apart from loan of rupees 6 lakhs given to the accused within 2 years, amount of rupees 18 lakhs have been given out by the complainant and his financial capacity being questioned, it was incumbent on the complainant to have explained his financial capacity.
That is on the basis of that facts,
Not
on the basis of a suggestion. Here, in this case, there were documentary evidence led by the defense, which creates a doubt as regards his financial capability, that he is capable. But in your case, where are those materials?
Now, the Supreme Court says, on next line, my lord, I'm just taking your lordship's indulgence on this point. The court cannot insist on a person to lead negative evidence. I cannot lead evidence to prove that he is not financially.
No, you need not, but you have to probabilize.
My lord.
If you are raising this defense, then you have to show something. Something has to be there. Mere suggestion in the during cross will not be said to have discharged your burden. There has to be something more to that, which is lacking in your case. Say, for instance, in this case, go back to that paragraph, which is just reading. Are you following what is coming?
Yes, madam. Madam, lordship is absolutely correct.
Come to para 26.
26, madam.
In cross-examination. Of PW1. Read from there.
In cross-examination of PW1, when the specific question was put that the check was issued to a loan of, in relation to loan of rupees 25,000 taken by the accused, PW1 said that he does not remember.
So number one here, in the facts of this case, he doesn't even remember that that why this check was given. He says he doesn't remember whether it was in loan of the 25,000 or not. He doesn't even remember. Then read further.
PW1 in his evidence admitted that he retired in 1997, on which date he received a monetary benefit of rupees 8
lakhs,
which was encashed by the
so this
complainant.
He had admitted this.
Yes, madam.
That on that date, in 1997, when he retired, he had received a monetary benefit of rupees 8 lakhs. Then,
which was encashed. It was also brought in the evidence that in the year
2010,
the complainant entered into a sale agreement for which paid an amount of rupees
4,50,000.
towards
Payment of 4,50,000 being admitted.
admitted.
And further payment of loan of 50,000 with regard to so and so was filed by the complainant, copy
Yes.
which also filed as exhibit D2.
Yes.
There was burden on the complainant to prove his financial
Financial
capacity.
capacity. Yes, madam.
That is why I'm
Yes.
saying you cannot simply say that a suggestion was put questioning his financial capabilities and therefore now it is his burden. You see, even the fact that he had been paid 8 lakhs, otherwise, if you see, it does not discharge you from the reasonable doubt.
Madam.
But here the standard is not reasonable
Madam.
doubt. The standard is to probabilize. That much you have done.
Yes, madam.
Sorry, in this case,
Yes, ma'am.
the accused have done by bringing all this evidence,
Madam.
where apparently the complainant himself admits
Yes.
that yes, he received 8 lakhs at the time of his retirement, and he has, and then there are documents to show
Yes.
sale transaction of land 4,50,000. Then where is the question of taking a loan of 25,000? And in that context, the apex court has said there is no legal, it is not proof that the
Yes.
amount is towards a legally
Legally
enforceable debt. Correct, nothing wrong in that. The ratio has to be applicable to the
Facts.
facts of a particular case. Yes, one or two things matches with your case, but you cannot simply pick up those 1, 2 lines and say that yes, you have made out a case. You have to show that
Yes, ma'am.
where are those materials.
Your lordship is absolutely correct on because otherwise, my lord,
You've
As
done
your
your
lordship-
best.
my lord. But
Anything
facts
more?
sometimes.
Mr. Das is getting anxious now.
My lord.
Anything more? Are you done, Mr. Naman?
My lord,
All right. Yes,
subject to
Mr.
what he
Das.
says, my lord.
Of course, you'll get a right to reply. Yes.
My lord, this matter, my lord, it's a revision petition and my lord, the revision is their case is basically, my lord, on 2 grounds, my lord, no, 3 grounds.
3 grounds.
One, my lord, income tax, that part, my lord. Neither that was taken a plea in the trial court.
Income tax.
Yes, my lord, they are saying
That
that
was there in the
exceeding
grounds, okay,
payment
but
of
we are not
20,000.
stressing on that.
He has not argued
Yes, my
that.
lord.
Please reply to the
I'm-
grounds that is argued.
Yes, my lord.
They may take several grounds in their petition.
I am just highlighting, my
No,
lord.
no, but
Yes.
you stick to the grounds which is
Yes,
argued.
I'll
Why-
come
why
to that,
do
my
you
lord.
argue a ground which is not even argued before this court?
Yes, my lord.
Yes.
I'll come to that, my lord. Second, my lord, the plea is that the son has taken some money, my lord, that has been dealt with by the trial court as well as by the appellate court. And my lord, thirdly, my lord, the quantum of the debt, my lord. This is the sum and substance, my lord.
Quantum of the debt.
My lord, that is, the payment has been made to the son. Quantum is 1,07,000, not the 3,20,000. And that is the third plea, I suppose, my lord.
How do you categorize that as a quantum? of
Part
the debt?
payment has been done, my lord.
What
That
he-
is.
what is an
that is
argument
what.
is to show, see, the 3 things that has been argued before this court. Number 1, that there is no legally enforceable debt
My lord.
because it has not been proved as when this loan was taken. A. Secondly, since it was suggested during cross that you are financially fully capable, the question of you taking a loan doesn't arise. This is one of his argument, right? Second, he says that there is evidence to show that the son has already been paid half of the payment of the loan. Therefore, this amount in the check could not have been for this particular transaction. This is what he is saying, second. And the third one was these 2. And the third is, what was your third argument? These are the main 2
Main
arguments.
argument.
So these are the
So
2.
far as, my lord, the present case is concerned, my lord, that will include his submissions also, my lord. The transaction has not been denied by the accused. person.
Correct. Correct.
The, my lord, lending of check has not been disputed. The signatures has not been disputed.
Disputed.
The receipt of notice has not been disputed, my lord. And, my lord, so far as, my lord, the first part that the transaction part, my lord.
Yes.
It is rather in the cross examination they have put, my lord. I'm just reading the required part, my lord. আসামীৰ লগত মোৰ একবাৰে লেনদেন হৈছিল আৰু এই কেছটো সেই লেনদেনৰ ফলত হৈছিলে। So
So he's admitted that that
Admitted.
one-time transaction between him
Admitted.
and the accused.
accused, my lord. And so far as my lord, the question whether I had the capacity to lend, my lord, he has in the cross-examination part, it was put to the complainant side and he said, my lord, মোৰ ৰিটায়াৰমেণ্টৰ পিছত টকা আছিল বুলি আসামীক মই দিছো। So he had money for retirement benefits, he had, my lord, with him, and that is why he had given this money to the, my lord, some of the money to the accused.
Oh, so he have said that.
He has said that in the cross part, my lord. Then, my lord, so
So
far
he
as,
explained,
my lord,
he have explained in the cross
explain in the
that
cross,
he has money from, which he has got from his retirement benefit.
Retirement benefits.
On being retired.
my lord,
And out of that, he has
He had
paid the loan.
paid the loan. my lord. So far as the son taking the money, my lord, he has not denied that son has not taken money or son has taken
Because
money.
he doesn't know.
He doesn't know for what purpose he has taken money, my lord. And my lord,
What does he, yeah, can you read that part of the cross?
my lordship, মোৰ লৰাই 1,07,000 টকা কিয় বেংক অফ বৰোদাৰ পৰা ড্ৰ কৰিলে মই সোধা নাই। He has not asked his son. And before that, my lord, সত্য নহয় যে আসামীয়ে মোৰ লৰাই যদি 1.7 লাখ টকা বেংক অফ বৰোদাৰ পৰা চেক যোগে ড্ৰ কৰি আনিছে মই নেজানো। So amount part he
So
doesn't
he
know.
is saying he doesn't know.
He doesn't know. And if he has, if his son has withdrawn, he doesn't know that for what purpose he has withdrawn. my lord. And my lord, it is also not the case of the accused, my lord, that he had issued 2 numbers of checks to the complainant. One was encased, his son had encased the money, and the another one was, my lord, dishonored. And that resulted in filing of this particular case, my lord. He said one transaction took place, he issued
Which is
one
of a
check as
lesser
security
amount.
check, and then, my lord, he said that check got dishonored. Subsequently, in the cross part, he had built up this new aspect, my lord, wherein the PW1 said, my lord, that I do not know about the transaction of the accused and that had taken place with my son. my lord. So his argument
Does
also,
not take him anywhere.
my lordship. So if it would have been his case that he had issued 2 numbers of checks, one got dishonored for this particular transaction, my lord, it is not his case that he issued 2 numbers of checks. For one transaction took place between the complainant and the accused. That has come up in the cross-examination. And the moment it is put that your transaction has taken place, that meaning thereby that they have accepted that the transaction
There is a
has
legally enforceable debt.
taken place, my lord. That is what, my lord. And in fact, their own witness, my lord, the DW1, my lord, he in his cross-examination has said that exhibit 1, that was the check issued to me, and exhibit A to my son, A,
Where? Who have said?
cross part of DW1, my lord.
Okay.
Exhibit 1 আৰু exhibit A চেকৰ মাজত কোনো সম্পৰ্ক নাই।
DW1 is who?
One bank official,
No, he have said what?
he has said, my lord, exhibit 1 আৰু exhibit A. Exhibit 1 is the check, my lord.
Okay. The
Issued to
second
me.
question.
Yes, my lord. And A is check issued to my son, my lord. He said, my exhibit 1 আৰু exhibit A চেকৰ মাজত কোনো সম্পৰ্ক নাই।
So your argument basically is that
My
there are
argument-
sufficient materials based on which the trial court has convicted.
Rightly convicted.
And therefore, this revisional court ought not disturb these findings.
My lord.
This is your
My lordship, because,
submission in short?
my lordship, because this particular proceeding will not be, my lord, with regard to the factual aspect, my lord. Mostly it will confine to the legal proposition of the case. Whether, my lord, legally, my lord, if anything, any wrong apparent on the face of the record has been committed.
Correct.
Because so far as the factual aspect of the case is concerned, my lord, that has been rightly held by the honorable trial court as well as the appellate court, my lord. Only, I would be allowed to, my lord,
Yes.
to place the trial court's observation, my lord.
Yes, please. Mr. Nawaz, take your seat.
Para 16, my lord, perhaps my learned friend has already read over, my lord.
Page?
Page 27, my lord.
Yes, para 16.
My lordship, this is appellate court's judgment, my lord. Para 27, page 16, my lord. May I read, my lord? Appreciating the materials on record, it is found that the complainant has able to prove the check in question amounting to rupees so and so issued by accused appellant. Although a question was put to PW1, Sasanko Kumar Das, that the accused appellant had paid rupees 1,07,000 only out of the check amount to the son of PW1, but the same has been denied by PW1. DW1 Konok Bordoloi, although has proved payment of 1,07,000 only through check, the exhibit D and the statement of account of accused appellant in form of exhibit B, but the same is not sufficient to prove the contention of the accused appellant that he has paid the same to Kaushik Kashyap, the son of the PW1 against the checks. Now, my lord, page 28, para
Against the check
21.
exhibit 1.
My lord.
Exhibit 1 is the check in question.
Yes, my lord.
So this is what the court
This
has
is-
said.
yes,
There's
my
nothing
lord.
wrong in this. Against that, so that means that link is not there. That link
Link is not there. It has been paid against exhibit A, my lord.
That has
and-
not been proved.
Not been proved. And my lord, the DW1 has categorically said that there is no link between exhibit 1 and exhibit A, my lord.
And in that context, it is said that it is not believable.
My
This-
lordship,
This finding is absolutely correct.
my lord. Then, my lord, page 28, para 21. May I read, my lord?
Page?
28, my lord,
Yes,
para 21.
yes.
As per section 102 of the Indian Evidence Act, burden of proof in a suit or proceeding lies on that person who would, as per section 103 of the Indian Evidence Act, the burden of proving is to any particular fact lies on that person who wishes the court to believe in its existence unless it is proved by any law that a proof of that fact shall lie on any particular person. In the instant case, the complainant has not admitted the receipt of rupees so and so only from the accused appellant through the son of the complainant, and as such burden lies upon the accused appellant to prove the fact that he has paid the amount to the son of the complainant who had received the same on
Against the
behalf
check
of the
amount.
complainant
Against the check amount.
against the check amount. And my lord, who had received the same on behalf of the complainant. This has also been not been
That
put,
link
my
is
lord.
missing.
Link is absolutely
Link is
missing, my
missing,
lord.
and that link cannot be presumed.
Yes, my lordship. Now, my lord, the trial court's judgment, my lord.
If
the
this
page
amount was in the name of the complainant, then of course.
My lordship. Then of course.
Just he's the
And
son
suggestion-
doesn't mean.
And no suggestion is there in the cross-examination that I have paid this amount of money as a part payment to your son instead of you, and your son has misutilized it. That is also not their case. Their only case is that they have given some money to the son, and now they
And they have not denied the transaction, that loan amount.
nothing, my lord.
That
Transaction
denial is not
accepted.
there.
Yes, my lord. Transaction rather they have
Can you
accepted,
read the 313 explanation once again?
my lordship. তোমালোকৰ আছে নেকি আৰু? নাই ন?
Mr. Nawaz can read if you permit him.
My lordship.
এই গোচৰৰ বিষয়ে আপোনাৰ ক'বলগীয়া কি? মই মোৰ টকা প্ৰয়োজন হোৱাত তেওঁৰ পৰা 1,60,000 টকা লৈছিলো 2011 চনৰ মাৰ্চ মাহৰ শেষৰ ফালে। 2012-13 মাৰ্চত মই তেওঁক বৰোদা বেংকৰ চেকৰ জৰিয়তে 1,07,000 টকা তেওঁৰ পৰিশোধ কৰো। তেওঁ পুতেকৰ নামত উক্ত চেক দিবলৈ কৈছিল।
So
Hey.
in his explanation, he clearly agrees that because of financial difficulty, he had sought a loan from the complainant.
Complainant of 1,60,000.
60, that is the amount he is.
He says.
And that amount is repaid to the son.
Son on the instruction of the complainant. He says it like this. তেওঁক বৰোদা বেংকৰ চেকৰ জৰিয়তে 1,60,000 টকা তেওঁক পৰিশোধ কৰো তেওঁৰ পুতেকৰ নামত উক্ত চেক দিবলৈ কৈছিল সেইমতে মই দিছিলো আৰু উক্ত টকা এনকেশ হৈছে বাকিখিনি টকা মই তেওঁক বেলেগ তাৰিখত পেমেন্ট কৰিছো তাৰ পিছত
So what was the loan amount he said?
1,60,000
And 1,60,000 is already paid to the son. How much has been paid?
1,07,000 paid. The amount is doesn't
No, no,
match.
I'm trying to understand the explanation.
My lord.
Yes.
তাৰ পিছত তেওঁলোকে মোৰ ওপৰত কেছ দিব
You see,
এনেদৰে
this is the explanation. Now you have to prove this explanation. In order to discharge that burden, you have only you have shown that it is the son, number one, that you have paid so and so amount as you claim to his son. This part is proved by bringing DW1.
We are
Correct.
also not denying.
Correct. And they have also not denied. But whether this is for that loan or not, that is missing. And something, if something more is not there, how can the court say that you have probabilized the probabilized it and or that the you have discharged the burden? Yes, Mr. Das.
Lord, then page 43 of the petition, my lord, from para 22, that is the judgment of the learned trial court.
Yes.
May I read, my lord? Page 43, para 22. The other ground which the defense side has taken in is that a part of the borrowed money, rupees 1,60,000, a sum of rupees 1,07,000 has already been paid to the son of complainant by means of a check drawn on Bank of Baroda by the accused. Hence, there is no debt or liability as claimed by the complainant. That is their ground, my lord. Now, my lord, in order to substantiate the above ground, the defense side has examined one DW, Sri Ranjit Kumar Das, who is the senior branch manager, Bank of Baroda Tejpur branch. The said DW has stated in his examination in chief that Sri Konak Bordoloi, accused, had issued a check bearing number so-and-so dated so-and-so of amount rupees 1,07,000 to Sri Kosik Kashyap through his account number 1/5841. The said money was paid to Kosik Kashyap through transaction number so-and-so. Exhibit A is the said check proved in original, and on the back side of the check, two signatures of Kosik Kashyap are written. In the statement of account as on 31/3/2012, the fact of payment of 1,07,000 to Kosik Kashyap has been mentioned. Exhibit B is the statement of account as electronically maintained, and exhibit so-and-so is the certificate written by his own hand. The evidence of DW1 does not establish the fact that the accused had given 1,07,000 to Kosik Kashyap, who happens to be the son of complainant. I find nothing to doubt the assertion of DW1. However, nowhere in his evidence it is mentioned that 1,07,000 was given to Kosik Kashyap in part payment of the original debt which the accused had owed to the complainant. In other words,
he has not filed a reply, right, to the notice.
my lordship,
He did not file, the accused did not give reply to your legal notice, right?
not my lord.
Not given, isn't it?
Not.
So for the first time in his 313 statement,
The stand has been taken, my lord.
he has taken the stand that the money was paid to the son,
Paid to his
isn't
son,
it?
my lordship.
No, just one
Uh,
point, madam. The notice was deemed to be served. It was not served.
No, it's all
So
right.
we could not reply, madam.
When it is deemed to be served, it is assumed that you have got it.
But my lord, they have not denied that they have not received
No,
it.
they
Yes,
denied.
my lord.
They have denied.
It
The
is.
notice is deemed to be served.
No,
So
no,
we
T1
take
TL
it.
নব, কাকিটো লাগিব নহয়।
See, admittedly, your the stand of you giving this money in respect of that loan to Kosik Kashyap is at your 313 explanation,
My lord,
not before that.
No, madam.
there is no evidence, my lord.
No, madam. During cross-examination also. Cross-examination also. This was from the very inception. This was our contention. Cross also we took up this.
In the cross you had.
Cross also. Service we are not disputing because now the law is that even after court can always presume service, madam, if it is sent to the registered.
Okay.
But in our 313, we said that we did not receive the notice, hence no reply was given, madam.
Yes, Mr. Das.
My lord. Then, my lord, I was reading
24.
para
44.
24, my lord. Third line, my lord.
Yes.
However, nowhere in his evidence it is mentioned that 1,07,000 was given to Kosik Kashyap in part payment of the original debt, which the accused had owed to the complainant. In other words, there is no evidence to establish that link, or at least to create reasonable doubt that the money was given in part payment. In fact, DW1 has himself stated that there is no link between Exhibit 1 check and Exhibit A check. It has also stated that it is not mentioned in Exhibit A that there was connection with Sasanko Kumar Das. Now, my lord, para 25. Moreover, the transaction was between the accused and the complainant. There is no reasonable explanation as to why accused had chosen to pay the amount of rupees 1,07,000 to the son of the complainant, instead to the complainant, although he had borrowed from the complainant. The son of the complainant was not privy to the transaction.
He's already,
He has
shown
come
it.
to a finding, my lord. That is the, my lord, otherwise sum and substance of the finding of the learned court below, my lord.
Mhm.
So, my lord, unfortunately, my lord, this transaction took place in the year 2012. And from the retirement benefit, my lord, the complainant had lended that money, my lord. Now, my lord, this case, my lord, during the pendency of this case, he expired. Now his wife is a party to this case, my lord. So, my lord,
Anything more?
my submission is, my lord, I'll confine to my, my lord, submission that, my lord, the revisional, my lord, aspect of this honorable court, my lord, there is apparently
No error.
no error, my lord, on the face of the record with regard to the legal.
There's no legal
aspect of the
infirmity.
case. Yes.
All
my lord.
right.
And the factual aspect of this case has already been dealt with by the trial court as well as the appellate court rightly, my lord.
All right.
That is my humble submission.
Just
Yes.
One aspect on this, though this is otherwise maintainable, a civil suit as well as an NI case is maintainable. I'm only submitting on the quantum of the punishment. Should your lordship please to dismiss this revision petition? They have preferred a money suit, which was decreed in their favor, and they are also check amount along with 8% interest have been 8% interest on this check amount has been awarded to them.
Has been?
Awarded to them, my lord.
Have you paid?
No, this just judgment has come just around 1 month back, my lord.
So what is the judgment?
In the money suit, my lord, they prefer.
No, we don't know. Tomorrow you might appeal.
No, we will appeal. My just pointing it out. Just pointing it out, my lord.
This is only confined to 138 of
Yes,
negotiation.
and here it is only returning that
Yes.
amount. That is the punishment given in default 5 months.
5 months, my lord.
There is
The
no
amount is
question
also
of
very
Just
less.
pointing out the quantum.
modification or anything. Yes.
Rather than, amount is also very small, my lord. Rather
No,
than.
it is
my lord,
not about the amount. If if we find the conviction is correct, there's no question of modifying that the quantum of the penalty.
my lord.
Merely because some judgment has been passed in the civil case. We don't know. If you would have shown before this court that you have made the payment, then of course.
Then we have not got the time because it just got. Anyways, we'll prefer an appeal, my lord.
At 2, I shall dictate.
My lord. Yeah, my lord.
You have something?
My lord.
You ask your junior to be around,
My lord. Deeply obliged.
I'm deeply obliged.
but ask someone to
Yes,
be
sir.
around because the only purpose of dictating in open court is to ensure that no facts are wrongly recorded.
Yes, my lord.
Lawyers knows the facts the
Yep.
best. Yes, Mr. Chaudhary,
Deeply
anything?
obliged.
May I take a little liberty, ma'am?
Yes, please.
There is that matter, item 24,
Is that a part heard matter?
part heard matter. Ma'am. Your lordship will recall, is that prosecution sanction matter?
Yes, yes, yes.
I had completed my arguments already.
Yes,
So I am not really feeling well.
no problem.
I have
think
prepared
the
a.
day I was hearing this petition, that day I was not feeling well, for which I think the matter got inferred.
My lord,
If I
Your lord-
recollect that matter, isn't it?
yes. In fact, we have prepared a brief written argument that should also help in refreshing all of
What's
us.
for the other side?
Mr. Nath, senior government advocate. He was supposed to make his submissions. In case any reply is required, my friend will be here. Your lordship will allow me 5-10 minutes on Thursday.
You inform Mr. I think.
Let them
we'll
make their
post it
submissions.
Post it on another date then. Put another date.
In that case, let it be day after tomorrow. Right? We can. It's a very otherwise short point.
All right. But you please inform Mr. Nath, in case he has any difficulty day after tomorrow, so that ask him to be here at 2, Mr. Chakraborty,
Yes.
you be here at 2?
Yes. I'll-
All right. Day after tomorrow, you said.
Yeah,
That is,
27.
Thursday. Thursday. All right, all right.
Otherwise, my lord, we have summarized everything in the written argument,
Very well.
including the case laws.
Regards to my English counsel also.
Hmm?
He is in lakes on court number 8.
No, no, you are making a mention.
No. In this case only,
Which case?
this pronouncement of judgment. Item 7
You are for whom?
for the respondent on behalf of MK Das.
Huh?
On behalf of MK Das. Manjit Kumar Das.
Your item number?
Are you not his junior?
Yeah, I am his junior.
Yes,
He is
me
also-
too.
He has already informed this court. One of you be around. Yes. No, no, Mr. Nath, matter to matter. Mr. Nath,
Item number 24.
24. The petitioner has submitted some written arguments. Have you got a copy?
No, I have not.
Please give him a
I'll-
copy.
ah.
You have a look at it. And we are fixing it on Thursday. Is Thursday convenient?
Day after tomorrow. 27.
Item 24. Mr. Heard, Mr. I. Chaudhary, Leonard Senior Counsel, assisted by Mr. B. Chakraborty,
Yes.
S. Chakraborty. Also heard Mr. D. Nath, Leonard Senior Government Advocate for the state respondent. Mr. Chaudhary, Leonard Senior Counsel, has submitted written arguments today in the matter. Let a copy of the same be also furnished to Mr. D. Nath, Leonard Senior Government Advocate for the state. Relist on
On
if
27.
Thursday.
27, day after.
27.
Item 17.
17 is for judgment, huh? Yes, take your seats. Heard Mr. S. Nawal, Learned Counsel for the petitioner. Also heard Mr. M.K. Das, Learned Counsel, appearing for respondent number 2. State is a party. And MS S.H. Bora, Learned APP for the state respondent. Stop. By way of this petition under section 401, read with section 397 of CRPC 1973, the petitioner is seeking, is assailing the judgment and order dated 14/3/2018, passed by the learned additional session judge Sonitpur Tejpur, hereinafter referred to as the appellate court in criminal appeal number 14 within bracket S3 of 2016, whereby the appeal filed, appeal filed by the petitioner was dismissed by upholding the judgment and order dated 15/9/2013, passed by the learned additional Chief Judicial Magistrate Sonitpur Tejpur, hereinafter referred to as the Magistrate Court in NI case number 39 of 2013, registered under section 138 of the NI Act. Stop. The brief facts of the case is that a complaint petition was filed by the respondent number 2 on 6/1/2014. No, was filed on 6/1/2014, alleging inter alia that the petitioner that the petitioner, upon seeking financial help from him by way of loan, he in good faith lent him a loan of rupees 32 lakhs. 32,000 or lakhs?
3 lakhs. 3,20,000.
3 lakhs.
3,20,000.
Loan of 3,20,000. Right. Upon the promise of the accused of the petitioner that the same will be repaid after 2 months. However, thereafter, and it is the further alleged case that after 2 months, the complainant had asked for his money, and accordingly the petitioner issued a check bearing number 009825 dated 12/9/2012 of Assam Grameen Vikas Bank Tejpur branch for rupees 3,02,000 in favor of the respondent number 2 in discharge of the aforesaid loan. However, upon presentation of the said check, the check was returned. The check was returned back due to insufficiency of funds. It is further alleged that thereafter the upon the request of the petitioner not to send legal notice, and that the balance will and that to present the check in the month of December when he will have sufficient balance in his account, the respondent number 2 represented the check in the bank for payment on 10/12/12. However, it was again dishonored, showing insufficiency of fund. Accordingly, it is alleged that legal notice was sent on 9/1/13 demanding the petitioner to make the payment of the check amount. However, despite receipt of notice, the said payment was not made. Accordingly, the complaint petition was filed, wherein the magistrate court took offense took cognizance of the offense under section 138 of NI Act, and after concluding the trial was pleased after conclusion of trial was pleased to found the petitioner guilty under section 138 of the NI Act, and accordingly convicted him and sentenced him to fine to pay sentenced him to pay a fine of rupees 3,80,000 and a lump sum interest amount. No, 3,80,000 in default SI for 5 months. Stop. Being dissatisfied with the said judgment of the magistrate court, the petitioner filed an appeal before the appellate court. Wherein the appellate court, by judgment and order dated 15/9/2016, was pleased to dismiss the appeal by upholding the conviction given by the magistrate court. Hence, the present revision petition. Mr. Nawaz, learned counsel for the petitioner, submits that that the petitioner, having discharged the onus under section 118 of the NI Act, has probabilized has met the has proved the defense by meeting the standards of preponderance of probabilities, and hence the judgment and order of both the appellate court as well as trial court is totally erroneous in law. In support of the, no, don't say now, he further submits that there being no legally enforceable debt due to the respondent number 2, comma, no offense under section 138 of the NI Act is established, and hence the judgment and order of both the trial court as well as the appellate court warrants to be warrants interference from this revisional court. Stop. He further submits that the accused, having questioned the financial ability of the respondent number 2, there could have been there could have been no legally enforceable debt. He further submits that part payment of the loan amount having been paid to the son of the petitioner, which is clearly established by the evidence of DW1, comma, no offense under section 138 is established, and comma, then you say the petitioner has rebutted the presumption under section 118. Stop. In support of the aforesaid submissions, he relies upon the following cases of the apex court. number 1. Manju Ram Kalita versus State of Assam, reported in 2009, volume 13, SSC at page 330. John K. Abraham versus Simon C. Abraham and another, reported in 2014, volume 2, SSC at page 236. Number 3, Basalingappa versus Mudi Basappa, reported in 2019, volume 5, SSC at page 418. Per contra, Mr. Das, learned counsel, appearing for the respondent number 2, vehemently opposes the prayer of quashing the prayer of setting aside the judgment and order of the appellate court, not vehemently, while vehemently opposing, comma, has submitted that both the appellate court as well as the trial court, having not committed any error apparent on the face of the record, the revision petition is liable to be dismissed. Stop. He further submits that upon the presumption being drawn under section 118 of the NI Act against the petitioner, it was the petitioner, comma, the onus was on the petitioner to rebut the said presumption by adducing material evidence. Stop. He further submits that apparent on the face of the record that no material evidence whatsoever has been adduced by the petitioner to rebut the said presumption, whereas on the contrary, the petitioner has admitted the signature on the check and the loan taken by him from the respondent number 2. He accordingly submits that the judgment and order of both the trial court as well of the trial court being based on evidence, as well as of the appellate court being on the not both. Okay, both the trial court as well as appellate court being based on evidence, comma, sufficiency of the same cannot be looked into by this court while exercising the powers of revision. Stop. Heard, perused, considered. Okay. The prosecution has examined 3 witnesses including the complainant himself, and exhibited documents in support of its case. whereas the accused whereas the accused was examined under section 3.1, whereas the accused has been examined under section 313 CRPC, wherein he stated that he has committed no offense, and examined and adduced one witness being DW1 in support of his defense. It appears from the evidence of CW1 stroke complainant that he has clearly stated, clearly deposed in support of the statements made in the complaint. It appears that the aforesaid testimony of the CW1 could not be shaken by the petitioner during cross-examination. It further appears that the testimony of PW1 has been corroborated by the other prosecution witnesses. It further appears that the petitioner tried to rebut the presumption on two grounds. Firstly, that the petitioner had borrowed rupees 1,60,000 from the complainant and had given a blank check to the complainant as security measure and secondly, a sum of rupees 107,000 has been paid to the son of the complainant as by means of a check drawn on Bank of Baroda against part payment of the borrowed money. It further appears that in order to prove the aforesaid defense, the petitioner has examined one DW, Shri Ranjit Kumar Das, who is the senior branch manager, Bank of Baroda, Tejpur branch, who deposed to the effect that the petitioner had issued a check bearing number 531195 dated 13/3/2012 amounting to rupees 1,107,000 to the son of the respondent number 2 through his account number 101/5841. it appears that he has further exhibited the said check as Exhibit B. No, it further appears that he has exhibited the statement of account showing the aforesaid payment to the son of the complainant, which is exhibited as Exhibit B. It appears that there is no evidence it appears that there is no evidence to show that to establish that the said sum of rupees 107,000 paid to the account of the son of the complainant was against the loan borrowed against the loan given by the complainant to the petitioner. That being so, it cannot be said that the petitioner has proved his defense by probabilizing by meeting the standards of preponderance of probabilities. In order to meet the preponderance of probabilities, there has to be some evidence on record for presuming that for rebutting the presumption, not presume, for rebutting the presumption. In the case of Manjuram Kalita versus state of Supra, don't say that, not this one. No? In the case of John K. Abraham, Supra, relied by the Learned Counsel appearing for the petitioner, it appears that though the magistrate court, after considering the oral and documentary evidence led on behalf of the complainant, having rendered the judgment and order, the same was interfered by the appellate court the same being reversed by the High Court in appeal, the apex court has made the following observation, quote unquote, paragraph 10. Paragraph 10 of the judgment, of the aforesaid judgment, no? No, you make quote unquote 7, 8, 9, and 10. Okay. In the instant case, there being no there being no there being no lack of material particulars in the case of the prosecution, comma, the aforesaid decision does not apply to the facts of the present case. In the case of 2000, in the case of Baslingappa Supra, the apex court has held as hereunder, quote para 25, 26, and 30. By relying on the aforesaid decision, the learned counsel for the petitioner attempted, tried to tried to impress this court that when the financial, when the accused petitioner questions the financial ability of the complainant, financial capacity of the complainant, comma, it is incumbent on the complainant to have explained his financial capacity. And court cannot insist on a person to lead negative evidence. The aforesaid, there is no quarrel to the aforesaid proposition. However, in order to apply the said proposition in the facts of the present case, it has to be first shown by evidence, either by adducing himself or from the prosecution evidence, that the complainant is financially incapable of giving the loan. In the present case, it appears that the complainant has merely, the petitioner has merely suggested during cross-examination of the complainant as regards his financial incapabilities, which was denied by the complaint. That being so, I'm afraid that the aforesaid contention of the learned counsel appearing for the petitioner cannot be accepted. In the case of Manjuram Kalita Supra, the apex court has held as hereunder. Para 9, 10, okay. By relying upon the aforesaid decision, Mr. Nawaz, learned counsel for the petitioner, submits that in a given situation where the court below has not considered the material facts and did not take into consideration any admissible evidence, the revision court is entitled to set aside and quash the judgment and order of the appellate court. I am afraid the aforesaid submission cannot also be accepted in the facts of the present case, inasmuch as the reading, inasmuch as it is apparent from the judgment and order of the trial court as well as the appellate court that both the judgments are based on evidence after the same being considered and after the same being considered. Stop. Apt to refer to paragraph paragraph 15 to 26 of the judgment and order of the trial court, which is reproduced hereunder for ready reference. Page, I said which paragraph? Page 15, page 42 onwards. Apt also to refer to the relevant paragraphs of the judgment and order of the appellate court, which is reproduced hereunder for ready reference. Quote unquote, para 16 to para 22, page 27. Reading of the aforesaid judgment and order of the appellate court as well as the trial court, I am of the unhesitant view that both the courts have not, that there is no legal infirmities in the aforesaid judgment and order. Hence, the revision petition fails. Dismissed. Sorry.
This is very difficult.
Item 19 and 20.
May I please, Your Lordship? On the last occasion, that is on 4 March, the
Trial court records.
trial court record.
Lordship, there is office note, Lordship. 21/3/25, Lordships. Trial court record not yet
Has not been received.
Not yet received, Lordship.
Reminder In view of the order passed earlier by this court on 4/3/2025, calling,
No, you see appellate court.
no, one second,
Trial
one
court.
second.
Appellate court, no?
In view, no, peruse the office note dated 21/3/2025, wherein it is clarified upon verification by the registry that case records of CR case number 5927 of 2008 as called for from the SDJM within bracket S number 2 Kamrup M on 21/11/2022 has not yet been received. Stop. That being so, let reminder be sent forthwith calling for the aforesaid records from the trial court. List after 2 weeks on a date to be fixed by the registry.
I love it.
21.
Last 21.
Seems nobody is appearing for the petition.
None appears for the petitioner or and the respondent number 2 on call and the private respondent on call. MS.SH Bora, Lalit APP for the state is present. Relist
After due vacation.
after 3 weeks on a date to be fixed by the registry. I have seen Mr. Mohanta sitting here, but where's he gone?
His junior was dear Lordship. His junior was dear Lordship.
But where are they now? This is the last matter on board. You are also there.
Lordship. Today they were supposed to give you some judgment, Lordship, regarding the conversion.
Oh, this is that matter.
T23 to fine, Lordship.
Where are they?
They were sitting here, Lordship.
What to do?
Can I see outside, Lordship? He may be there. My office never been.
Yes, where is Mr. Mohanta? Oh.
Give me one Lordship. Lordship, we want to place some judgment, Lordship.
You want to have it on another date in his presence, or you want to give the judgment?
Judgment, your Lordship. Only on the point of the punishment, your Lordship. And it can be granted at
Because I remember on the last occasion you had argued the matter, and when I have kept it for giving the judgment, Mr. Mohanta had come and requested the time.
Yes.
That is why I'm asking you.
Yes, Lordship.
If he has to come and submit, then I'm going to.
Inclined to grant that benefit of that provision of offender act, then Lordship.
Huh?
Lordship can be inclined to grant that the benefit of provision of offender act. Lordship. It's that leading judgment on the Supreme Court, your Lordship, Sitaram Paswan, and that recent judgment passed by that man.
Where, which paragraph?
I mark it, your Lordship. Sitaram Paswan.
So having regard to the circumstances, including the nature of the offense and the character of the offender.
Your Lordship, though it's that trial court judgment was not
What is
observe
the,
that it's a
what is
simple injury.
the sentence given?
Lordship, 3 months. Lordship.
So, and have you, look at the nature of the injuries?
Yes, Lordship. In that,
Incised wound over right up lid on the lateral aspect.
Lordship,
Cut wound over left lower half of a lip. Abrasion over forehead. Black eye.
Lordship met comes to para 15 of that trial court judgment, Your Lordship.
Yes,
Yes, Lordship. In the last line, Your Lordship.
yes.
I hold that the injury were simple in nature, Your Lordship. This is the observation, Your Lordship. And that,
Yes, and accordingly, sentence have been given.
yes, Lordship. And
But,
it's a fit case for grant the benefit of the provision of offender.
sorry, not going by the injuries.
Your Lordship.
Injuries are, if it was one injury, yes, of course. 4 injuries. It's a discretion of the court.
Lordship, that
The decision that you have shown also says,
yes, Lordship. And the
if the
recent-
court thinks that having regard to the circumstances of the case, including the nature of the offense and the character of the offender, benefit should be given. So, nature of the offense cannot be ignored.
And the recent 2 judgment passed by this High Court.
Yes,
The 2 judgment.
the
Yes,
coordinate bench.
Yes, Lordship.
Yes. The nature of offense and manner it was committed cannot also be said to be heinous or premeditated, inasmuch as admittedly there was quarrel. It isn't that facts have suffered for last 20 years, considering and without entering into the merits, settled period lapsed. These are on the facts. They are contextual. In the context.
Yeah, Lordship, must have it, yeah.
No, because you see, there is no error that he could point out.
Lordship, error, Lordship,
The arguments you've already done. You could not point out any error as such. You wanted this court to reappreciate the evidences.
evidence and
Isn't it?
Yes, Lordship.
That how can this court do?
The trial court mainly on the point of
The first ground for the learned trial court and learned appellate court committed grave error in appreciating the evidence on record and facts and circumstances of the case. You have not argued any point of law. What provision of the law or what law has been ignored? That is not argued by you.
must have it, yeah, Lordship.
No, you can try. You keep trying. You are doing very good. Don't give up merely because I am saying if you want to reinforce your argument, please do it. But not by asking this court to look into the evidences. You have to point out because you are before a revisional court, correct?
Yes, Lordship. Your Lordship, revisional court mainly admitted in 2 grounds, Your Lordship.
Because you see, even all your grounds appears to be failed to appreciate the contradictions, fail to appreciate the fact that the alleged victims were examined by the medical officer without police requisitions.
Yes, Lordship.
Fail to appreciate the evidence on record of PW9 in proper perspective. How can this court go into all this?
Lordship, that's why we are in the revisional court, Your Lordship.
And that is why you
appellate
have
court
very
considered, Your Lordship.
clearly submitted that at least if it could be considered under the probation, correct? That was your alternative submission. That is 360.
360 and 361 is a clear, Your Lordship.
360 and
361, Your Lordship, provisions.
361.
361, Your Lordship.
360.
360, about 361, Your Lordship. And 3.
Yeah. Please.
61 টো আপোনাৰ যদি গ্ৰান্ট কৰে এইটো দিব লাগে ৰিজনটো দিব লাগে যদি গ্ৰান্ট কৰা নাই তেতিয়াও লিখিব লাগে Your Lordship, special reason to be recorded in certain cases where in a case
1 second. You're reading?
361 provision of CRPC.
Yes.
Your Lordship, here in the provision that appellate court or trial court should be record the reason why it's not been granted a benefit of 360. Why is it it's not the granting that benefit of 360, Your Lordship? But appellate court does not record any sentence, Your Lordship. There is no only line, Your Lordship, in appellate court judgment.
Your punishment was? Here, what was the sentence?
Your Lordship, punishment 3 months, Your Lordship.
3 months plus 500 rupees.
It was 18 years ago, Your Lordship. Peak of the moment was happened, Your Lordship. They didn't.
But you see
Given the
here, the trial court has recorded.
The trial court observation is our side, Your Lordship.
Huh?
The trial court.
No, trial court, as regards the sentence,
And in last part, Your Lordship, 2026.
yes, I remember
Then
seeing this.
the nature of the
Accused
institute-
persons are heard on the sentence considering the nature of injuries proved to have been sustained by the injured. I hold that the accused persons could not be extended the benefit of release on probation of good conduct under section 4 of the probation so and so. However, considering the fact that the accused persons were not habituated,
offender.
they were not proved to have been convicted earlier, the accused persons are sentenced so and so. You have already been considered. Now, after this,
Your Lordship,
you
this
see,
observation is our favor, Your Lordship. We
Huh?
are not this observation is our favor, Your Lordship. We are not
this
habitual
observation is,
in my favor, Your Lordship. We are
that
not.
and accordingly has given you simple imprisonment
Your
for
Lordship.
15 days and 3 months.
3 months, Your Lordship.
That is why.
And the appellate court, Lordship, appellate court would have done that same thing, Your Lordship. Appellate court, but they don't record any sentence, Your Lordship, regarding that 360 of the provision of indirect benefit.
There's a point in that. The trial court has clearly held. But here they have given a reason. Heard on the sentence considering nature of injuries, which I was also saying, proved to have been sustained by the injuries, I hold that the accused persons could not be extended the benefit of release. But considering the facts, they have imposed a lesser punishment. Now, once that is exercised by the trial court and a reason has been given, matter ends there.
No, sir, Lordship, the appellate court has to be given some observation, Your Lordship.
No, appellate court will give
Very-
it only when the trial court has not given
That's
the
right.
reason. Then the appellate court or the revisional court can give it. But when the trial court has already, why should the appellate court look into this? Appellate court is not imposing the sentence. Who is imposing the sentence?
Lordship, trial court, Your Lordship.
Then that part of your submission cannot be accepted. In fact, you see in 360, it says an order under this section may be made by an appellate court or by the High Court or Court of Session when exercising power of the revision. Which power? the power under section 360. Right? An order maybe, it says maybe, correct? That means when in a given situation, if if under subsection 1, the trial court has not done it, then because in 360 special reasons to be recorded in certain cases, wherein in any case the court could have dealt with but has not done so, it shall record in its judgment the special reasons for not having done so. The trial court has already recorded that going by the nature of injuries.
And the injuries were your lordship doubtful, your lordship, that they are not escorted by that the lordship investigation official, your lordship. And evidence part is it was clear.
PW3 have said that she heard a commotion and when she came out of her house, she saw the accused persons bringing two persons to her house
House, yes, Lordship.
and gave them drinking water.
Yes. This the PW3 witness are not considered by that trial court, Your Lordship. That is a specific ground, Your Lordship.
These persons are the injured persons.
Yes, sir. Injured person were taken to the home, Lordship, in PW3 years.
They have confined these person, the victims in their house, Lordship. They confined them, Lordship. They confined them in a house, Lordship. Or something.
And Your Lordship, petition number 3, Your Lordship, Purnananda Guhai, there is no any single sentence that whisper in the trial court judgment, Your Lordship, regarding him, Your Lordship. Purnananda Guhai, Your Lordship.
How many accused were there? 3.
3, Your Lordship.
All 3 have been found have been convicted.
Lordship.
All the 3 have been convicted.
Yes, Lordship.
Mr. Locker, any reference of the about the role played by number 3? What is the name?
Purnananda Hazarika, Your Lordship.
Any reference about whether he has dealt any punch or anything from the evidence? Anything is there?
May I read that PW3, Lordship?
1 second.
প্ৰদ্যুৎ হাজৰিকক চিনি নাপাওঁ, আছামীজনক চিনি পাওঁ। 1-1-2007 তাৰিখে ঘটনা। মই তেতিয়া ঘৰতে আছিলো, ৰাস্তাত হাল্লা শুনিছিলো। মোৰ কেঁচুৱা থকা বাবে ৰাস্তালৈ নগলো। আছামী সকলে এজন নেওগ বুলি মতা আৰু এজন মুঠ 2জন মানুহক আৰু আমাৰ ঘৰলৈ লৈ আহে আৰু তেওঁলোকক পানী আদি খাবলৈ দিয়ে। তেতিয়া পুলিচ আহি নেওগ আৰু তেওঁৰ লৈ যায়।
And in cross?
Decline.
Acha, PW1, can you read?
মই দিয়া এজাহাৰ প্ৰদৰ্শক 1 মোৰ this is প্ৰদ্যুৎ হাজৰিকা। প্ৰদৰ্শক 1 মই দিয়া এজাহাৰ প্ৰদৰ্শক 1 মোৰ চহী। আছামী সকলক চিনি পাইছো। 1-1-2007 তাৰিখে আবেলি 3:30 মান বজাৰ ঘটনা হয়। মই বুঢ়া লগৰী থকা মোৰ পেট্ৰল পাম্পলৈ গৈ আছিলো। মোৰ লগত মোৰ লগৰ ল'ৰা ইন্দ্ৰজিৎ নেওগ, ৰাহুল আগৰৱালা, ৰাজেশ আগৰৱালা আৰু বাকী নেকি
বাপ্পী সেনগুপ্তা।
বাপ্পী সেনগুপ্ত আছিল। আমি গাড়ীৰে গৈ থাকোতে গোলাঘাটৰ পৰা আছামীসকলে অপেন জীপত আহি আছিল। তেওঁলোকে আমাৰ বাট আগচি ধৰে। তেতিয়া মই মোৰ গাড়ীখন ৰাস্তাৰ কাষলৈ নমাই দিলো। তেতিয়া আছামীসকলে গাড়ীখন পাৰ হৈ যায়। তেওঁলোকৰ গাড়ী তাত থৈ যাওঁতে আছামী পূৰ্ণানন্দ গোহাঁই মোৰ গাড়ীত ঢকিয়াই দিয়ে। তেতিয়া মই গাড়ী এখন ৰখাই দিওঁ। আমি ল'ৰাকেইটা গাড়ীৰ পৰা নামো। তেতিয়া আছামীসকলে গাড়ীৰ পৰা নামি আৰু পূৰ্ণানন্দ গোহাঁইয়ে ইন্দ্ৰজিৎ নেওগৰ চকুত ঘুচা মাৰি দিয়ে। ৰাজেশ আগৰৱালাও আছামী কেইজনে মাৰপিট কৰে। আছামী কেইজনে পূৰ্ণানন্দ গোহাঁই আছামী কেইজনে মাৰপিট কৰে। ৰাজেশ আগৰৱালাৰ নাকত আৰু মুখত মাৰে। তাৰ পিছত
So that he have said Asami, I was thinking maybe one of the accused, nothing is there, but he has said Purnananda Gohai specifically and the other 2 witnesses had also assaulted Rajesh Agarwala. They had administered punches on the nose and face of Rajesh Agarwala.
Yes, Lordship.
Is Rajesh Agarwala examined?
Rajya examiners.
নাই কৰা,
PW?
নাই কৰা, নাই কৰা।
6, Lordship.
Yes, please read.
প্ৰদ্যুৎ হাজৰিকাক চিনি পাওঁ, প্ৰদ্যুৎ হাজৰিকাক চিনি পাওঁ, আছামীসকলক জনক চিনি পাওঁ। 1-1-7 তাৰিখৰ ঘটনা, মই প্ৰদ্যুৎ হাজৰিকা, ইন্দ্ৰমণি, ইন্দ্ৰজিৎ নেওগ, বাপি সেনগুপ্ত,
গাড়ীৰে গৈ আছে।
ফুলগুৰিলৈ গাড়ীৰে গৈ আছিলো। আছামীগণ 8-9 জন জিপেৰে বিপৰীত ফালৰ পৰা আহি আমাৰ বাট ভেটি ৰাস্তাত গাড়ী ৰখাবলৈ দিয়ে। আমি চাইড কৰি দিওঁ। তেওঁলোকে মোক আৰু ইন্দ্ৰজিৎ নেওগক মাৰপিট কৰে আৰু ৰাজীৱ গগৈৰ ঘৰত বান্ধি থয়।
But nothing he doesn't say about the punch.
আমাক ইন্দ্ৰজিৎ আমাক মাৰধৰ কৰে বুলি কৈছে।
Court question.
ইমান তাৰিখে ৰাস্তাৰ গাড়ীখন ৰখাই দিওঁ, আমি চাইড কৰি দিওঁ, তেওঁলোকে মোক আৰু ইন্দ্ৰজিৎ নেওগক মাৰপিট কৰে
Okay.
আৰু ৰাজীৱ গগৈৰ ঘৰত বান্ধি থয়। অলপ পিছত ঢেকিয়াল আৰু
So it is corroborated. Corroborated. Difficult.
Lordship, done me sometime. My senior will appear.
Huh?
My senior will appear, Lordship.
What is this?
Lordship, he will file that written argument, Lordship.
What written argument? I asked you in the beginning.
Yes, sir. If he is in division bench, Lordship, BB1 will.
No, but that is why I said we can have it on another date. I gave you the option. But you see, it's not right that you do a trial and error before the High Court. You attempt, and if you see that no, I am not being able to convince, then you want to adjourn the matter on the pretext that your senior will come. If you would have sought for that adjournment, there's no difficulty. In fact, this court was willingly giving you, because I remember on the last occasion also similar thing has happened. You had argued very well.
Yes, he was there, Lordship.
You had argued very well, I must say, but when the time came for this court to give the dictation, you sought time. You didn't sit there. You got your senior. Who sought the time?
Yes, Lordship.
Huh?
I am closing for that, Lordship. My senior, he was supposed to appear.
Tomorrow at 10:30.
Tomorrow at 10:30, Lordship.
Relist as item number 1, as on the top of the list. If I do Mr. Locker, just see the evidences once. If anything is there for this court to exercise the powers under Section 4, and also because see if there are any decisions of the apex court, you also see where it says that even when the trial court has already considered the case under Section 4 and rejected it by a detailed order by giving reasons, the appellate court or the revision court still can re-exercise that power.
That power, yes.
Because I'm wrong, therefore I'm asking, please get me some decisions on this point.
Lordship.
At 2 or at 10:30?
At 2 will be better.
All right. At 2, top of the
At
list.
2, Lordship, tomorrow, actually, tomorrow I have some program at my residence, Lordship. So, Lordship,
Thursday?
Thursday, Lordship.
Released on Thursday at 2. Huh? As part of it. All right.
Lordship.
Please get me if
Lordship.
you can. Thank you.
Alright.